Sir, turn your cell phone off and put it away, please. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. All persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division, First Department. I'm sure you're glad to get inside from that, I don't know, Armageddon out there. Any event, you're in our beautiful courtroom and we're happy to see you. I just want to remind you that we have had your briefs and records and we are familiar with your cases, and I ask that you only request the time for argument that you really need to explain the important parts of your cases. Otherwise we would be here all night with the requested time. So I remind you, when the red light goes on, you should be finishing up your sentences, and if we still have questions, we will continue to ask them. That's pretty much it. So I'm going to call the calendar. When I do, if the appellants and respondents on the appropriate case would get up, and you'll let me know how much time you think you need, and we'll give you how much time we think we can. All right, the first case for argument is People versus Sammy Lopez.
I have not heard from counsel, but I presume he is submitting. I'm here for respondent.
He's submitting.
He's not here. Mr. Sheehan.
Okay, so are you, did you want to argue if he's not here, or did you just want to mark?
No, I'm respondent.
Okay, so, well, mark it submitted. If they come in before, please have a seat. Thank you. You'll let me know. The next case for argument, Kaufman versus Kaufman. Wait, just stand where you are. Appellant, tell me how much time you're requesting?
My name is Noah Kaufman, the appellant, pro se, 10 minutes, Your Honor.
And the respondent? 8 minutes, Your Honor. Okay, I'm going to give you, sir, 6 minutes and 2 to respond, and I'll give you 6 minutes, okay? Thank you very much. You may be seated. F. Emily versus Victor P. Okay, the appellant? How much time? 12 minutes, Your Honor. And then who else do we have here? You're the respondent and you're the AFC? Okay, and how much time did you want? 5 minutes. Okay, and AFC? Okay, and I'll give the appellant 5 and 2, and each of the respondents 5. Well, I'll give you 6 and 2, and each of the respondents get 5 minutes. Next, thank you all. Next case, Deutsche Bank versus Procel. Anyone here? That case is marked submitted. Aaron Law versus New York City Police Department. Okay, I'll give the appellant 5 minutes and 2 for rebuttal, and I'll give the respondent 4. Thank you. Barlow versus Scrupus.
Good afternoon, Your Honor. Appellant's request 8 and 3.
Your Honor, counsel for the respondents will take 6 minutes.
Okay, so I'm going to give you 6 minutes, 6 and 2 for rebuttal, and I'll give you 6 minutes. Thank you. People versus Kiedis.
For appellate, 5 and 1, please.
Okay, and respondent?
5 minutes, please.
Okay, 5, 1, and 5. Thank you. Matter of Carmen CS versus Gnu. Rebuttal. Okay, and. Okay, I'll give you 5 and 2 for rebuttal and 4 for the respondent. Thank you. The next 2 cases, Maknovich versus Board of Managers. And respondent? Okay, I'll give you 5 minutes and 3 for a rebuttal, and I'll give you 5 minutes. Thank you very much. Southern Advanced Materials versus Robert Abrams. Yes, I know. And respondent? I'll tell you what I'm going to do. I'm going to give you 8 and 2, and I'll give you 8 and 2. And if we still have questions, we'll keep going, okay? Thank you very much. People versus Jared S. Okay, that's submitted. Pinnacle Managing versus Slade Industries.
Respondent requests 5 minutes.
Okay, 5, 2, and 5. Thank you. People versus Darnell Holmes. Okay, that's submitted. The next case is Kazina versus Kazina. Sorry if I misplaced. You got it. 4, 1, and 4. And the last case is Tittle versus the City of New York, and that case is marked submitted. So the other side has not come in on that first case? No? Okay. So the first case for argument then is Kaufman versus Kaufman. Okay, would you please step to the microphone with your papers, and you'll be able to speak from the podium, okay, Mr. Kaufman? Okay, you may proceed. Good afternoon.
Good afternoon, Your Honors. May it please the court, my name is Noah Kaufman. I am the petitioner appellant pro se in this matter. Thank you for the 2 minutes of rebuttal. I come before you today seeking justice for my mother, Rebecca Kaufman. My mother is a vulnerable elderly person with a disability. Rebecca Kaufman is unable to defend her own interests because she suffers from Alzheimer's disease. Rebecca Kaufman is entitled to an honest and trustworthy fiduciary. I pray the court will provide the relief of a hearing to settle the issue of whether Rebecca Kaufman is being financially abused by her guardian. I further ask the relief of having this court void the so-called Medicaid trust order issued in October 2021.
So counsel, if I may, I understand that this guardianship is based on consent, is that right?
The original petition which I brought was settled in a lower court on a consent decree.
And in this instance,
A consent of the alleged incapacitated person.
And in this instance, your mother is deemed to be a person in need of a guardian, not a person who's incapacitated. Is that correct?
That is my understanding of the order given by the previous justice.
Okay. And the court conducted, thank you, questioned her personally as to what her...
Not in court, to my knowledge, Your Honor. There has been no hearing on her capacity.
The court never interviewed your mother?
I cannot say what the court did, but certainly not on record.
Did your mother designate your brother Seth to be her guardian?
That is my understanding.
And your issue is that your brother has abused his responsibilities?
Yes, I have raised numerous red flags of his untrustworthiness, of the matters of fact are in dispute and do require a hearing to determine the matters which are of material fact which are in dispute. So I was seeking additional relief to void the so-called Medicaid trust order, which was issued in October 2021. That order harms my mother. It was based on misapprehension of material fact, and moreover, it breaches the governing order and judgment. I bring this appeal under an error of fact and an error of law standard. Firstly, a hearing is warranted and needed to verify the facts and produce an accurate accounting in Rebecca Kaufman's best interest. A hearing is warranted because the material facts are in dispute. I have submitted sufficient evidence to raise a genuine issue of fact as to whether the guardian, Seth Kaufman, my brother, has been embezzling funds from our mother's estate in violation of his duty. The guardian has failed.
Counsel, if I may, didn't the court deem that the value of your mother's estate increased from I believe your brother was appointed in 2020, so it increased in value during the time that he's been the guardian?
There is a dispute of material fact that there is more than $110,000, which is not accounted for in his reporting, and the time that that money was entrusted to his care, Your Honor.
But didn't the court evaluate or review the figures and the reports and so on and find that
I cannot
everything was in
say,
good shape?
the court examiner was
I'm calling
appointed.
it a court examiner.
The court examiner did issue reports. They have been, I've notified the court and the examiner of my concerns, including the missing title of his reports. I see our time is limited, but I do want to ask or answer any of your questions, Your Honor. The missing funds certainly represent a year of private care for my mother. The respondent claims that the funds were spent in 2018. This is contradicted by the record on appeal, and I refer to you to page 148 of the record. That record shows that my mother was living very comfortably within her means in 2018, but it appears to me that the trial court overlooked that part of the record. Because she was living within her income in 2018, it contradicts the respondent's claim that the money was spent, the missing $110,000 was spent on my mother's care. So the respondent is not quite clear on the record of the missing cash assets. I believe a hearing is needed to determine where that money went and to whose benefit it went. I also submitted evidence of missing assets that raised the genuine issue of fact as to the guardian's fidelity. In my brief, which you have, I noted that the prior court and the examiner have overlooked the following red flags for fraud that were found in the guardian's annual report for 2020, namely that the guardian did not marshal Rebecca Kaufman's Capital One bank accounts, that the guardian did not report all of Rebecca Kaufman's monthly income, potentially covering up embezzled funds. The guardian did not report Rebecca's gain to her investment principal, which you did mention, which is also an indicator of potential fraud. The guardian falsely inflated Rebecca's expenses on the record.
Okay, Mr. Kaufman, we're
Yes, Your Honor.
going to hear from the respondent, and you'll have a few moments to respond to anything you'd like to.
Thank you.
Thank you so much.
May it please the court, I'm Diane Temkin for respondent. I submitted a motion to the court to redact the respondent's name to protect her privacy, so I'll refer to her as Ms. K.
Okay.
And to clarify, the questions are before the court or are whether the trial court abused its discretion by not removing the guardian and whether the trial court abused its discretion in not vacating the Medicaid planning order. There's no issue before the court of Ms. K's capacity. that was settled. To answer the question that was put to the appellant, on page 1029 of the record, the first guardianship judge took testimony from Ms. Kay and found that she had capacity to consent to the guardianship. And the guardianship order of 2020 is not on appeal here. This is an order of 2022 where appellant made a motion to remove the guardian, which was his third or fourth time he sought to remove the guardian. The first time was, well, before his brother was appointed guardian, his brother had power of attorney, and appellant sought to remove his brother as power of attorney, alleging many of the same things he's still alleging before the court today. And though any of those things that were before the guardianship started in June of 2020 were settled by the guardianship order, where the court evaluator reviewed everything going back a few years and found that his brother, the appellant's brother, was the appropriate guardian, and it is also the guardian that Ms. Kay sought, that was her preference.
And the sister who lives in California, she has agreed to the current guardian, correct?
Yes, she filed, they both the other siblings filed cross petitions, and the sister Susan said that Seth should be the guardian, the present guardian should be the guardian.
And the reports, they're required to be reviewed by not court evaluators, but they're required to be reviewed each year, aren't they? I mean, isn't that part of the
Yes, at the time of this hearing, there was the initial report, and there was the first annual report, and
court examiners? That's
the court examiners report.
pursuant to Article 81, and the court examiners approved at least one, if not both, of those reports. Is that correct?
Yes, on the record, the second judge, there was a second judge for these proceedings after the guardianship. The second judge asked the court examiner about the initial report and the first annual report, and the court examiner found no irregularities. So now we have two judges and the court evaluator before the guardianship and the court examiner after the guardianship have all found that the present guardian is appropriate, and the court found there was no misconduct on the part of the guardian in pursuing his duties. And I would also like to say that in Article 81, it's the very first part of Article 81 and its statutory purpose says that the guardian must take into account the personal wishes, preferences, and desires of the person, which affords the person the greatest amount of independence and self-determination in all decisions affecting the person's life. And here in this case, we have Ms. Kay herself constantly expressing her preferences and wishes, and as in the record on page 476, she says, "I love all my children equally, but I have always said I do not want Noah to have any control over me or my property. I do not want him as a sole or partial guardian or anything else. He's the reason I have a guardian. I consented to avoid a trial, even though I had executed a power of attorney that was prepared by my attorney, Ira Saltzman. Noah is bossy and controlling, and he does not respect my privacy. He is saying that my prior decisions were not my own, which I find insulting and totally untrue." And finally, she said, "I would also like the court," and this was the court below, "to do what it can to make Noah stop all this needless court activity. I made decisions. Noah keeps trying to undo them." Thank you.
Thank you. Mr. Kaufman, you have 2 minutes to respond.
May it please the court to correct the respondent's decision, the lower court decision from which I am appealing would be the third judge in this matter. And so that would be an incorrect statement by the appellant. respondent. I want to note, and bear with me please, that the so-called Medicaid trust order does harm Ms. K, and I have no objection to calling the case or retitling it. It should be deemed null and void. The trial court stated in the order I'm appealing from that the guardian applied to transfer Ms. K's property in California to a Medicaid trust. In fact, the trust order disposed of Ms. K's real property interest and causing her to suffer an estimated $400,000 financial loss. In fact, the trust order disposed of Ms. K's real property to the benefit of a third party while leaving Ms. K 100% liable for the mortgage of the disposed property. Another material fact which the trial court misapprehended. The Medicaid trust order should be voided because it was based on the trial court's misapprehension of the fact. And the trust order harms my mother by breaching the gift provisions of the governing order and judgment. The trust order authorized my siblings, Seth and Susan, to engage in unlimited self-gifting without any court oversight, contrary to what my mother agreed to in the governing order and judgment before Justice number 1. The trust order represents my siblings' rush to drain our mother's estate before our mother can use her resources to provide herself with private care. And the Medicaid trust order should also be voided because it violates my mother's due process rights. It violates the gift restrictions of Rebecca's consent guardianship, thus morphing or changing this into an involuntary guardianship without a hearing before a justice. And so when the appellant respondent mentions testimony presented to Rebecca, I am of this sound opinion that it was somebody putting a pen in her hand and having her put the words in her mouth.
Okay, thank you. Thank you both very much. We'll certainly look at this carefully. Have a good afternoon. Thank you for coming in. The next case for oral argument is Emily versus Victor P. Good afternoon. You may
Thank you, Your Honor.
begin.
Good afternoon. My name is Karen Jansen. I am the attorney for the appellant. May it please the court. Is relocation in the best interest of the child? This is the question that this honorable court must decide on appeal. As we all know, relocation cases are never easy. There are no winners, there are no losers. We only wind up with a child who really loves both parents and who wants nothing more than to have that love at all operable times. In this relocation case, however, the court did not consider the relevant tropea factors as they related to the specific totality of the circumstances in this case.
Counsel, I have a question.
Yes.
In the Court of Appeals case of Brayman versus Brayman, the court sent back a case for a further hearing where there was a sense that things might have changed substantially since the underlying decision, and that the child's interests, what was in the child's best interest, might have changed. Would that be an appropriate consideration in this case? Or
You mean
an
to
appropriate
remand-
remedy in this case, to send it back for further hearings?
So I think, Judge, the fact of the matter is that the child is currently residing in North Carolina with his mother, has been in North Carolina for the better part of a year at this point. And so to remand it back down at this point for a new best interest analysis, I'm not so sure that that would really work here. And in fact, Your Honor, when you look at the underlying order that had been the basis for this petition, Mom had sole legal and physical custody. Dad had a quote-unquote visitation schedule. And so although I was not the attorney in the court below, technically she didn't really even have to file a relocation petition because, in fact, Your Honor, she had been driving the child up between...
And what impact did the move of the child from New York to North Carolina have on the father's visitation arrangement?
It didn't, Your Honor.
It came up in accordance with the existing arrangements?
I don't want to say each and every weekend, but for a majority of the weekends when the father was to have had access, despite the fact that the mother was in North Carolina, he had that access. And I believe that you will also hear from the attorney for the child that since the time that the mother has relocated with the child down to North Carolina, the father has waived a significant part of the time that actually had been afforded to him vis-a-vis the stay order that that this honorable court had issued.
Well, part of the problem that I'm struggling with in this case, and it goes back to something Justice Gessmer just asked you, is we normally take a record as we find it, as it was adduced before Nisi Prius. Well, now we know, given the core issue here being best interest of the child, we may throw that sort of general principle, cast that principle aside and consider matters that are otherwise doors the record. And much has occurred since Justice Rosado issued her underlying order. So I would like to go back to Justice Gessmer's question about, would a potential remedy here be, an appropriate remedy, be a new best interest hearing?
It wouldn't be inappropriate, Judge, but I don't believe that it really would be the best decision at this point. Again, considering the year that the child has been there. And I do believe you will hear from the attorney for the child how well the child is doing at this point. The fact that he has been able to maintain, at least to the extent possible, a relationship with his father, that the mother, my client, the appellant, has driven the child back and forth between North Carolina and New York. And so as far as, listen, a best interest hearing, I think, would inure to my client's benefit, because I do believe that a court will find that it is in the child's best interest at this point to remain in North Carolina with his
Counsel,
mother.
there were some problems early along, or at least during the time when Judge Rosado had the Lincoln hearing, with perhaps the mother taking the phone, and so that the child was not having the continuous contact with the father that he wanted, and he said he had to either use the mother's phone or he couldn't talk to his father. Is that all been resolved?
Well, Judge, I have that on one of my lists of things that you would have asked. While it is true that the mother, quote unquote, took the child's cell phone, that was really a parenting decision that had been made, and perhaps inartfully asked by lower court counsel for the appellant. I think that it is pretty clear that what was happening with this child, who was 6 or 7 at that time, was that he still had access. The testimony is that in the transcript was that the child had access to the mother's cell phone during the time when he didn't have his own cell phone. And why a 6 or a 7-year-old needs to have a cell phone is beyond me, but that's another question. He also had access to an iPad, Your Honor. And so even though that cell phone had been taken, it didn't necessarily mean that the father was cut off from communication with the child, if that answers the question, Your Honor.
And he's 10 years old now, right?
He's older now, yes.
What other family members are there in New York, and what other family members are there in North Carolina?
So it is my client, her daughter, the child's half-sister.
Who lives with them.
Who lives with them. Her fiancé at this point, and she has various aunts, uncles there in North Carolina. And I believe that the respondent has some family here. I'm not specifically sure. I do know that he refers to grandparents as living in the building, but those are not grandparents. Those are really neighbors. And I think that the transcript is pretty clear that the contact with the father's extended family was somewhat minimal. They did go on some outings, et cetera, but I don't know that it was all that extensive, Your Honor. Remember, this was a visitation schedule where the father had alternating weekends, holidays, some vacations. He would be able to maintain that. And my client, as a matter of fact, Your Honor, and I think that the record is rife, offered that on numerous occasions. Holidays, long weekends, lots of summer access in order to make up for the time that would have been lost by not having the actual alternating weekends.
Okay, thank you. We'll hear
Thank you, Your
from the respondents, and you'll have a few moments to respond. Thank you.
May I be seated?
Yes, please.
May it please the court. My name is Karen Steinberg, and I represent the respondent, Victor P. I think that my brief clearly lays out my argument in this case, but I think that there are a few...
Counsel, I have a question or two. In the record, it suggests that your client waived the opportunity to have the child with him for a month last summer. Do you disagree with that? Do you agree that he waived that,
My
that the mother
understand,
gave him the opportunity to have the child with him for a month and that he declined to do that?
I wasn't the attorney for Mr. Victor P. at the time. My understanding is that it is perhaps true that he did not avail himself of all
And
of
is there
the...
some reason? I mean, in the record, there was no reason given for that.
So part of the problem here is that...
Let me ask you this. Does the record state any reason for why he did that I missed?
I don't believe it does.
Okay.
And
My
I think
other
that...
question was, it appears to me from the record that your client never attended a parent-teacher conference during the time the child was attending PS3, never attended any other events at the child's school, never went to a doctor's appointment. Do you disagree with any of that?
No, but he did explain why in his testimony.
Right, but all of the events that were part of his explanation were 3 or 4 years old, and he hadn't done anything since then, right?
Yeah, but I think that it informed his relationship with the mother of the child, who was not cooperating with him in a lot of ways.
There's no evidence of her lack of cooperation
Well, he testified...
within the last 3 or 4 years, is there?
No, but he testified that previously
I
she had
understand,
not...
but after that, he didn't take any steps to see if she was more willing to be cooperative.
There's nothing in the record that indicates that, Your Honor.
So what was the explanation for that lack of contact?
That, well, he was seeing his son every weekend, so he was every other weekend, and talking to him all the time on the phone. He was texting on the phone, calling him, and he indicated that he and the mother had a contentious relationship, that she was constantly filing petitions against him in court. She filed several family offense petitions alleging domestic violence, which she then withdrew. So he was constantly going back and forth to court. And I believe that he felt intimidated. His testimony was that he just couldn't take it anymore. He couldn't take all of the pressure that she was putting on him and all of the negative influence that she was having on him and not telling him about parent-teacher conferences or doctor's appointments or anything like that. And even, I mean, perhaps with the parent-teacher conferences, he perhaps should have reached out to the school on his own, but with doctors, if the child has to go for a doctor's appointment, it's on the custodial parent or the parent that takes the child to the doctor to let the other parent know. There's no indication that she ever communicated with him about any of those things. And, one of the major issues I think that the court looked at here, not only that the factors that the court needed to look at with regard to Tropea were not really met. There was no proof of anything. There was only her testimony. There was really no indication that she was engaged, she had any financial hardship. She bought a house in North Carolina, apparently. So none of the factors that the court had to look at in making a determination about whether or not she should be permitted to move were actually addressed properly. In addition,
Her inability to find a job in New York State was pretty well documented, wasn't it, in the record?
well, but she stopped looking. She looked for a job in New York State
For
from
9 months?
January of 21 to August of 2021 and stopped, and then moved on her own without the order of the court, which she knew even if counsel says that she didn't need an order of the court to move, she filed a petition.
Right, but there is nothing, she wasn't violating a court order, right?
There's no court order that specifically indicated that she could not move. That is correct.
Well, to sort of use an idiom appropriate for the day, sometimes where there's smoke, there's fire, and ultimately we are best interest of the child. The child has now been in North Carolina for approximately 12 months. What is there to suggest anything contrary to what your friend represented, that the child is doing very well in North Carolina?
I have no idea whether the child's doing well in North Carolina. He hasn't been, my understanding is that he hasn't wanted to visit. The mother is the person who has influence over him where he is in North Carolina. She is the person who moved to North Carolina without the consent of the father, without the consent of the court, without even telling
Has
the
she ever
father.
tried before to influence the child's outlook towards visitation or custody of the father?
Yes, I think that the fact that she took the phone away from the child and interfered in the communication between the child and the father prior to the court's decision in this case is telling.
I know your time is up very quickly. She decides to relocate to North Carolina in October of 2021. She doesn't have a job in North Carolina at that time. She doesn't actually get the job at Duke until February of 2022. Is that correct?
That's my understanding, yes.
Okay,
Thank you.
thank you.
Good afternoon. May it please the court. My name is Eva Stein of the Children's Law Center, and I represent the child who is now 10 years old. First of all, the mother made extensive efforts in New York. She made about 7 months. She took about 7 months, applied to over 60 positions within the New York area before then deciding that North Carolina would be a good place for her to look. She had family there. The cost of living was lower there. And at that point, she didn't move in October. She moved in February 2022 after she
So she didn't move until
received
she
it.
had a job.
She didn't move until after she had a job. She had pushed the date back, in fact, of the start date of that job. And then she offered the father the entire month of July 2022, and he waived that option and said he wasn't interested. That the reason for that was not in the record, but he testified that it was not, that his understanding was that taking the child for that visit was not contingent on him agreeing to her relocation.
Counsel, what weight, if any, should we give to the Lincoln hearing that the trial judge conducted in this case?
I'm sorry, can you repeat?
What weight should we give to the Lincoln hearing that the trial judge conducted in this case?
Well, in terms of the Lincoln hearing,
And I ask you because you're the only
Yes.
one besides us who has read it, so.
well, it's true that during the proceedings, the child was somewhat conflicted because he loves both of these parents and has good relationships with both of these parents. His position had been, up until that point, leaning towards moving to North Carolina with the mother, who has always been his sole and primary caregiver. However, his position in camera, it was a divergence. And it was somewhat surprising, even to his attorney, who was with him. But at that point, at the time of the in-camera, he had spent about almost 2 weeks with the father, and he hadn't started school in North Carolina, and he hadn't established a life there. Now, a couple of weeks later, when the court issued its decision, which was early September, and since then, and in numerous interviews since then, the child has been firm in his position that he wants to stay in North Carolina. He doesn't see residing there as having damaged his relationship with the father. They text with each other frequently.
I'm sorry, what is the basis for that assertion?
The child's position?
Yep.
I'm sorry, I don't understand.
Well, what's the page in the record that supports that?
Well, this is, I'm explaining what has happened since the...
And so, we find ourselves here, we have a record that was adduced before the family court judge. And that there seems to be a potpourri of facts that came out in that hearing and information that is purported information based on how he's done over the last 12 months, which, I'll go back to something Justice Gessmer asked one of your friends earlier. Is the best course of action here to have a new best interest hearing to evaluate on admissible evidence how the child is doing in North Carolina and potentially the child's view of his arrangement there?
Well, first I would strongly assert that the evidence was there at the trial, that relocation was in his best interest, whereas there was no support for transferring custody to the father because the mother had chose to relocate. The fact that she chose
Hold on, we got to separate those two things, right? We have the relocation petition on the one hand, right? And then we have the sua sponte change of custody, right? Those are two separate things. They're somewhat related, but they are severable.
I would disagree. I think the court was required to look at both of those things and to consider that having the mother in North Carolina with the child, comparing the mother in North Carolina with the child versus the child in New York with the father, what would be in the child's best interest? As the court said in Tropea, this isn't about blame. This is about the best interest of the child. The mother made extensive efforts to find employment here. She had been unemployed for over a year during the pandemic, the height of the pandemic, and she has another child to support. And she started looking and was able to find a job in 2 months. So there are numerous factors which I lay out in my brief about why the relocation benefited this child, but there is no support for the change of custody to the father. There was nothing to show that the father was a superior custodian. The father had very limited involvement, and to the extent that the father would like to blame that on the mother, the record shows that he made very minimal attempts to be involved. Although he testified that he wanted to come to the school, volunteer, to do all these things, he had never done any of that. And he had an order, the 2017 order gave him an independent, a right of independent access to the child's medical and educational records. And I do think that, the remanding to the court for a new trial would be very disruptive to everybody in this family. The child has been there since last June. The mother has no housing here, and she has no job here. So to force her to move back here and the child to move back here in order to then have another trial, I think would be really damaging to everybody involved.
Well, if there were a future trial, couldn't it be done remotely? If there were a trial on remand, couldn't it be done remotely?
I
Now that we
suppose,
know how to do that?
but the status quo would, the stay motions also, I think, that evidence is before the court. The mother had made an offer. She attached further exhibits to support her testimony. Trial, in the stay motions that have been before this court. And so some of this information is in the record.
But now again, we're going to a posture that we would never consider this sort of information on any other type of appeal that I'm aware of. But under Michael B. and that type of authority from the Court of Appeals, we can consider matters in a best interest of the child context that otherwise would divorce the record for the purpose of determining whether there need to be further proceedings before the nisi prius, not for affirming or making a separate merits-based determination ourselves.
I think that the record supports a reversal of this order. I think that it's clear that the court overvalued the geographic proximity when this was a relationship that the child had with the father that was really, the father didn't pick him up from school, he didn't go to parent-teacher conferences, there was nothing during the week that he was involved with. It was alternate weekend visits. And that's the kind of a relationship that the case law shows is well-suited to extended visits that are less frequent.
Thank you.
So you said that she didn't decide to relocate until she had the job. The mother didn't text the father on October 4th, 2021, that she intended to relocate to North Carolina?
That was in the record that she did text
In
him, but she
October.
testified that she hadn't. That's when she started applying to jobs, and that the position that she ultimately obtained, she was offered in.
She indicated that she was going to North Carolina before she had the job.
Yes.
But she didn't do it until she had a job.
She didn't move there until after she had a job, and she also filed a motion for interim relief for permission to move during the trial as well. Once she got that job offer.
Did she get, how was that decided, that interim?
That was actually withdrawn. I think the court decided that it would conduct the hearing, and it never issued any orders restricting her from moving. I just want to emphasize that whether the mother acted appropriately or inappropriately is not the overall concern here. It's what is in this child's best interest. And if you look at all of the factors, it supports that relocation is in his best interest, and remaining there with the mother is.
Okay, thank you.
Thank you.
You have 2 minutes for rebuttal.
Thank you, Your Honors. Just very briefly, I do just want to clarify that the mother, although she had been offered the job from Duke in February of 2022, she did not move to North Carolina until June of 2022. She permitted the child to finish out his school year, did not disrupt him, did not pull him from that which he had known in the middle of a school year. And Duke, as a matter of fact, was able to delay her start date, and so it wasn't until June of 2022 that she actually moved to North Carolina, and I think that is also reflected in the record. I also concur with the attorney for the Child's Counsel that a remand back down at this point for best interests really would not serve this child's purposes. You have all of the information before you, and as Your Honor pointed out, pursuant to Michael B., you are allowed to consider all of that information and in doing a best interest analysis. And I think that the record is pretty clear, especially the brief on appeal of the AFC, and that even since the order, the amount of time that...
Why do we do it the record of the Lincoln hearing, which at this point is almost a year old, isn't it?
I'm sorry, Your Honor?
What do we do with the record of the Lincoln hearing, which of course we have the opportunity to see, which at this point is almost a year old, isn't it?
So obviously I haven't seen it, Judge, and I do note from the court's decision that it considered it. But I also believe that, a Lincoln hearing is but one aspect of many that must be considered in this relocation and custody matter. And so you have a very young child, again, wanting to please both parents, not wanting to seem disloyal to either parent, the mother or the father. And so children say things when asked pointed questions in a very stressful type of environment. And if it pleases the court, I do believe that the relocation in this case should be granted. I think that the decision and order of the lower court should be reversed. And I do believe that, given the totality of the circumstances, my client did meet her burden of proof in showing that she painstakingly looked for work here in the New York area in, remember, a post-pandemic era where it was very difficult to find work. She was able to do so, she did so, and she was always willing to accommodate larger blocks of time for this father and shall continue to do so.
Thank you.
Thank you, Your Honors.
Thank you all very much. Thank you for coming in. The next case for argument is Aaron Law versus the New York City Police Department. Justice Friedman is recused from that case. Good afternoon.
Good afternoon, Your Honors. So this is a straightforward FOIL case, except for a little bit of a twist. I know Your Honors are all familiar with the record, but if I could just get into a little bit the procedural history. So there was a FOIL request made for records associated with an anti-Semitic attack. The NYPD declined to produce any of those records in the administrative process, citing the interference exemption, asserting that there was an ongoing prosecution of the individuals to whom the records related to. Immediately, well, actually concurrent, so what happened was petitioner filed an Article 78 proceeding to compel production of those records. Concurrent with respondents' answer, which was a cross motion to dismiss, they submitted all the records requested by petitioner, except for one, which they argued was sealed at that point, and concurrently made a cross motion to dismiss, arguing that the matter was moot because a complete production is made, and in their affirmation, asserting that the issue of attorneys' fees and costs, which was a cause of action in the petition under FOIL's mandatory fee shifting provision, was premature and be held in abeyance. You
refer to it as a mandatory fee shifting provision. Doesn't it vest a lot of discretion in the trial court as to whether or not to shift fees? That's not what I would. It seems to me a provision like that gives the trial judge a lot of discretion is not a mandatory fee shifting provision, is it?
So it was amended in 2018, and the word was changed from may to shall, and that's Public Officers Law 89 4C2. And the memorandum of justification is pretty lengthy.
But most of the issues in this case predated 2018, right?
No, Your Honor. All subsequent. The request, I think, was made in 2022, so 4 years after the amendment in the FOIL statute. The amendment by the legislature was done with a recognition by the legislature that attorneys developed what they called a sue us attitude, which is where they don't comply with FOIL until they're compelled to by a court of law. And very frequently, in that proceeding, they'll, quote, voluntarily make a production to forestall the fee shifting provision. And that was addressed by the Court of Appeals in 2017 in Medeiros that said, that's really doesn't do anything, and whether or not they characterize it involuntary, so long as it was subsequent to the commencement of an Article 8 proceeding, the petitioner is deemed to have substantially prevailed in regard to that production.
So, counsel, let's talk about the two-pronged standard that's set forth in Jaskaran versus City, where this court said there's a two-pronged standard with respect to attorney's fees. One, whether the petitioner substantially prevailed, and two, whether the agency had reached a reasonable basis for denying petitioner access to the records under FOIL. Here, the arrest took place in May 19th and 20th of 2021. Your request for records was filed in May of, a few days later, on May 25th, and you're told your request is overbroad, and it's basically generic. And you responded with an email appeal and said, give me a phone number and let me discuss the specific records that I want. Then there was a denial that's quite detailed, issued on May 27th, and mind you, not even 10 days had gone by since the arrests on those two dates. And in the denial, it says, these records can't be disclosed because there are pending criminal prosecutions. We can't give you these records because there would be privacy considerations. We can't disclose these records because disclosure could result in witness tampering or the tainting of a jury pool, and perhaps even causing a perpetrator to evade detection or prosecution. So you get the records after those prosecutions have commenced, and I think they were still pending at the point where you received the disclosure. Under this scenario and under this chronology, using the Jaskaran two-prong test, do you feel, oh gosh, it's red light. I just realized.
Go ahead. Ask the question.
Sorry. Do you argue that you substantially prevailed? And more importantly, do you deny that the agency had a reasonable basis for denying you access to those records?
Yes, Your Honor. So I understand that that's the crux of the case. So let me say two things. Yes, absolutely. So first of all, the seminal case for this matter is the 2012 Court of Appeals case, Lesher. Lesher interpreted the interference exemption, and what Lesher says is just because—
Lesher talked about the agency's requirement to provide generic, they have to identify the generic kinds of documents, they have to identify the generic risks, and I ask you, how does this letter, how does this denial not set forth the risks, not in generalized terms, but rather with specificity?
So the answer to that is because all the information sought was in the public realm in two places. One is it was an e-crim, as you see later on what the production was, and as Your Honor pointed out, the proceeding was still going on when they ultimately produced the record. So clearly the NYPD did not believe that it would interfere, or they would not have produced the records while there was an ongoing proceeding.
But you're not privy to the investigation that was taking place that would have been compromised?
No, Your Honor, I'm not at all, but it's their burden to show that there's details in those documents specifically that would frustrate that judicial proceeding. And that's what Lesher says, and that's what this court said in Dioso Festino, which we cited at length in our appellate brief and to the trial court, which that case was really analogous. Over there, Dioso Festino asked for camera video, body cam, where there was a deadly shooting. And there was a NYPD investigation of that shooting. They didn't give the records, and then the court said they should have given the records because they didn't meet their burden to show why those records, not why, how those records would interfere. Similarly here, the nature of the stuff we got was all given over to the defendant already under CPL 245. So the Lesher case is predicated on the United States Supreme Court case, that NRLB case that we cited, and that says basically this exemption is for the prosecutor tipping their hand. If information was already in the public sphere, and more importantly, given over to the charged party, to the defendant, the NYPD can't meet its required burden to show that it would somehow interfere because it's in the public sphere. So here specifically, all the records we ultimately got are in the record before Your Honors today. These records have genetic stuff generic, that were all given over to the defendant as part of Criminal Procedure Law 245 and are presumably on eCrim. They're the charges, the location, when the party was charged, the time, the date that the party was charged. So the burden is not petitioner's burden. The reasonable basis that Judge Perry, they didn't even argue reasonable basis anywhere in their papers. It was a pre-answered motion to dismiss. And the reason why is because they didn't have a reason. They didn't assert it during this proceeding.
Okay, let's hear from them, and then you'll have a couple minutes for rebuttal. Thank you.
May it please the court, Kevin Osowski on behalf of respondents NYPD. The only issue here before the court today is attorney's fees. And as Justice Gonzalez has already said, the standard here is a two-prong test of whether the appellant has substantially prevailed and whether the agency had a reasonable basis for denying those records. The timeline here is pretty critical, I think, and affects the question of whether there was a reasonable basis to deny those records.
Well,
So
initially, when you denied them, in fact, there were proceedings going on, correct?
correct, and in fact, the entirety of the administrative appeal below was resolved within 2 weeks of the arrest in question. So it's inherent in that denial, as well as explicitly stated in the multi-page letter that was provided to the appellants at that time, that there were ongoing proceedings that would be affected by the production of those documents. And then it wasn't until 8 months later that those documents were actually produced, and this was once the Article 78 proceeding had commenced, and when presumably the proceedings had advanced to the stage where production of those documents under FOIL and the possibility that those documents would be made available to the public.
So he said you didn't give any reason, but wasn't that the reason that you gave below, that there was this pending proceeding, and once the proceeding
Precisely.
resolved itself, then you were in a different position?
Precisely, and in fact, on page 24, 25 of the record, the court has the letter that was provided and the explicit language used in describing why these documents were being withheld, and explicitly noting that that the assessment of whether a law enforcement exemption applies is something that changes over time as the cases progress, and that at some point the case may progress to the point where the law enforcement exemption no longer applies, and so the documents can be produced. The argument that appellant puts forth today about these information being publicly available in some format or available on web crims, there's no record evidence for that. There's no suggestion that at the time that the FOIL request was denied, within 2 weeks of these arrests, that information was available in any format or had been provided to the defendants at that time. So that's not properly before the court to consider. And as this court has already acknowledged, Lesher merely sets the requirement that the agency provide the generic kind of documents and explain the risks involved in producing those documents. As is evident from the record, page 24, 25, NYPD did so in denying the FOIL request. Unless the court has any further questions, we rest on our briefs.
Okay.
Thank you.
Thank you.
Just want to address 2 points. One is I see all your honors are concerned with the proximity of the request to the arrest. So as you see, ultimately 7 of the 8 cases were given over. 1 case wasn't because it was sealed. We routinely make FOIL requests for anti-Semitic incidents in the city of New York with the NYPD. Now, we constantly do this dance that if it's too early, they don't give anything because they say it interferes. A few weeks later, they say, well, now it's dismissed and sealed, so you can't get any records. So the reason why the request was made immediately after was because ultimately now I think every single one is sealed except for 2 out of the 8. So the reason is because we're always running this line too early, too late. But beyond that, respondent's case essentially is, if you look at their administrative denial that Justice Gonzalez read earlier, it comes out that unlike Lesher, everything is really insulated and everything will interfere because everything in that's generic. There's not one line in their administrative denial that pertained specifically to the records that were requested in this FOIL request. The NYPD could literally generate that administrative denial to every case. It says there's an ongoing criminal proceeding. There may be witness tampering. There may be this. There may be that. Nothing connects to that anti-Semitic incident. So just by its very nature, if this court would indulge in respondent's argument, it would undo the Court of Appeals in Lesher. And this court's precedent in the 2 recent cases that we cited in our brief. Lesher specifically says every document that's subject to the FOIL request, they have a burden to show why release of that document would interfere with the investigation. They haven't done that here. It's all generic language. There's no even indication that they looked at the responsive documents prior to issuing their denial. The only thing they said is there's an ongoing criminal proceeding. There's no indication they even knew which responsive documents existed and which didn't exist.
But didn't Lesher sort of have a very, it sort of created a very low burden for the production of identifying these documents and being responsive, and it was and they made some reference, I thought, to generic type of.
It's exactly correct, Your Honor. And we were here last time. We signed our papers with Jewish Press Against NYPD, and Justice Acosta said despite their low burden, they didn't meet it. And that's also what this court said in the case Justice Gonzalez referenced of Jasker and against NYPD. And that's also what this case most recently said with the body cam footage in matter of Dioso Festino. Dioso Festino is almost a perfect match. It's literally body camera footage of a fatality, and there's an investigation going on of the fatality. And this court said there is no reasonable basis not to disclose it because they didn't meet their burden of articulating how the disclosure would somehow jeopardize it.
Okay, we're familiar with the issue, obviously, and we will look at these documents a little further.
Thank you, Your Honor.
Thank you both. The next case for argument is Barlow versus Skrupa. Wait just 1 minute. Okay.
Thank you. May it please the
Thank you.
court, Carla Kerr Stearns for plaintiffs' appellants. Plaintiffs bring 2 principal appeals before the court today, one a disclosure decision and the second on a dismissal decision. The first appeal concerns the appropriate penalty for defendants' willful failure, as the court below found, to provide disclosure in 3 years of litigation. On a renewal motion, plaintiffs also supplied evidence that defendants had affirmatively destroyed plaintiffs' corporate files, and that according to a former employee who submitted an unrefuted affidavit, which appears in the record at 416 to 17. CPLR 3126 provides for penalties which are just and proportional to the noncompliance, certainly. However, the only appropriate remedy here is default of defendants on their answers and dismissal of their counterclaims.
So, counsel, I was concerned about the allegations that were raised.
Yes.
In your view, there's been no disclosure by the defendants here?
Correct. The defendants provided the document that plaintiffs attached to their complaint, the one document they knew plaintiffs had, and they purported to send a Dropbox file that was inaccessible to anybody who accessed it, and it was marked simply emails. And then over 6 months of efforts, he claimed that he didn't find a flash drive to actually produce it, and never produced it after several discussions with the court.
And here, there was a discovery order in March of 2020, a preliminary conference order in February of 2021, and then 2 days before the deadline of the discovery deadline on March 12th of 2021, the matter is removed to federal court, only to be sent back subsequently by the federal court to the state court. So with respect to these allegations, you claim, Plaintiff Barlow claims that she was at least a 21st consultant or employee to leave without being paid.
Correct. And she was the first chronological plaintiff out of all of these plaintiffs.
So and she said that she left being owed more than she was paid as
Yes.
well.
That's correct.
So under the circumstances here, did the parties ever move for contempt or file a complaint with the Labor Bureau of the Attorney General's office or with the Department of Labor? Is there anything, was there information that you were able to glean from other sources, or has this been an outright shut door?
I had some documents from the plaintiffs that they had on their common systems with their home systems. All of them are digital these days, so some of them had been taken home. So I, in fact, produced over 400 pages to the defendants of the kind of spotty files that my clients had. That is the record that there is. There's no other record from defendants, particularly from the corporate defendant. And as I've said, there's evidence that the corporate defendant plain old deleted their files. So the evidence that there exists in the case was produced from our side, and I did do some investigation and found from other cases that have been brought against the same defendants, and people gave me a couple of those documents, and I did give those to the other side as well.
Oh, different question. If the defendants are precluded by the court, by the motion court, from using documents not provided pursuant to the November 2021 court deadline or pursuant to the I almost had the derogatory. Can you imagine? Pursuant to the interrogatories that you served, is it really true, as you allege, that you will not be able to prosecute your case properly under these circumstances?
Your Honor, I cannot bring a employment action without personnel files. I cannot bring any number of, it's like asking the plaintiffs to go to trial and clap with one hand. I mean, it's plain old ridiculous. They make assertions that they had extra sick days and weren't entitled to various levels of their damages, and yet supply nothing. So it's a completely a lack of good faith on the defendant's side. They would still be able to cross-examine and refute plaintiff's case on the basis of unsupported conjecture and assertions of lack of context when they themselves have supplied no context. They're actually able to bring their own counterclaims without supplying the documents.
What's the difference for you with respect to the courts precluding the defendants from using these documents and striking the answer?
Your Honor, they're still able to refute liability. They're still able to bring their counterclaims. They're still able to cross-examine on the basis of attacking documents without having to supply their own more damaging documents. They actually admitted to the court below that they owed these plaintiffs their salaries. So I have no doubt that the documents that were destroyed are because their damages and liability was only going to get worse. There are 7, 8 complaints, claims in this, and they're...
What happened with that admission of liability of owing the salaries?
Well, the judge attempted to use it to settle, but it was not affirm. No, the judge didn't even note it in her.
Won't it be a starting point for anything that goes on going forward?
Pardon?
Won't it be the starting point for anything going forward?
Well, it was an offhanded comment that they recognized that they owed these plaintiffs their salary, but there are a lot of other claims in this that require further support. For example, he claims that there's a business, false business claim.
Someone like Barlow says that she paid $40,000 as an employee or a contractor for a conference center and then didn't get back the money for it, and then she still continued on with them?
Well, I cited about 12 cases to the court where one of the tactics of the defendants was to ask in sort of a desperate move for the employees to let him borrow his Amex so that he could pay for conference rooms or catering, and then he wouldn't pay them back. And that's what happened to Ms. Barlow. So there's lots of, but honestly...
But she continued in their employ afterwards, didn't she?
Well, and because she was told she was getting it back.
And she did get paid back, not
In a separate
enough, but-
case, I had to bring on motion in lieu of summary judgment. I did bring that case and got the 40 back. But there are plenty of other plaintiffs owed the same thing. In fact, there were 2 cases in federal court that I cite where they were also owed 40 or 50,000. I believe there was somebody who had used their parents' credit card, and they didn't get that back. But my concern is really all the rest of the claims that are in this, including false business advertising and many other claims that require actual discovery. And if they aren't willing to
Counsel-
supply that, I deserve
Counsel, can you
liability.
wrap up, because we're way over the time?
Yes, of course, and then there's a dismissal motion, right, and 2 were dismissed
Okay, well, you know
without
what?
benefit of any discovery.
All right, let's hear from your adversary, and we'll give you a few minutes to respond. Okay, thank you.
Good afternoon, Your Honors, and may it please the court. I would like to just begin, I guess we'll start with the discovery motion.
I'm sorry, who are you and who do you
I'm
represent?
sorry, I am Adam Engel. I am representing the respondents. Thank you. I'll start with the discovery motion. I think that what plaintiffs did in their brief, or appellants, they essentially edited the CPLR and said that the court did not have authority to do what it did.
What
which was-
discovery did you provide?
So there was, we collected discovery and produced it via a Dropbox link. And both parties have had this dispute. Both parties have had documents they couldn't open and had to go back and forth to the court. And that's what I was getting to, which is the court below is in the best position to assess what's an appropriate remedy for all
Counsel,
of.
could you answer the question as to what was provided?
Yes, there were a series of emails provided, and I believe there were other documents in the Dropbox folder. And that, I mean, that's essentially it. There were some personnel.
I have a problem with parties that don't comply with court orders. What judge doesn't feel that way, right?
Right.
And here, you have a discovery order, you have a PCO, and where's the compliance? Why shouldn't your answer be stricken?
So, first of all, that's for the trial court to decide.
No. We're the appellate court, so why shouldn't the answer be stricken?
Right. The answer should not be stricken because if you look at the chronology, there was an initial conference order which required discovery. We then filed a pre-motion letter to move to dismiss the complaint. And in response to that, the plaintiff said, well, instead of responding to that on the merits, we'd like to just amend the complaint. And at that point, we raised that that would deprive my client of the automatic stay of discovery. And so there was, the case then moved to the federal court where those discovery dates came and went. The court ultimately remanded it, but only because the plaintiffs amended.
Wait. You said that the discovery dates came and went. When it goes to federal court, the same dates and discovery orders remain in effect. You don't get to ignore them because you got moved to federal court.
Correct.
So I'm not sure what you meant by saying the discovery deadlines came and went. They were still there. So did you ignore those?
No.
So did you comply with them?
No, we didn't comply with them because we had raised.
They didn't come and go. You ignored them.
We did not ignore them.
You did not comply with them.
No, we did not comply with them, and I'll explain the gap in the middle. We raised discovery disputes with the court numerous times. There was many conferences with the court.
Were the deadlines extended in the federal court? The deadlines that you didn't comply with?
No.
So the fact that you raised something doesn't excuse your failure to comply, right?
Right. And the court addressed that. And ultimately, after conference, and we had many conferences with the court's principal law clerk, the court set new dates. We raised disputes with the court. We issued discovery responses to the discovery requests. We felt they were extremely overbroad. Many of them were directed at extremely invasive discovery into defendants Katz and Luff, who were, in fact, ultimately dismissed from the case. There were subpoena issues that the plaintiffs had issued to my client seeking all bank records, including which ended up resulting in the production of my client's children's bank records. So all of those were before the court. And the court, on balance, under the totality of the circumstances, looked at everything and fashioned a remedy that they felt was appropriate.
But the thing is, so what Judge Billings does is she precluded you from introducing into evidence any documents you hadn't produced, correct? Oh, isn't that part of what she did? Or
Correct.
any, if there had been interrogatories you hadn't responded to? But isn't part of the problem plaintiff may need some of these documents to prove her case? So if you're not allowed to introduce these evidence, that may still not help the plaintiff in proving her case.
That may be true, but we issued objections to many of the documents that are at issue. So what the court said, you have to respond to discovery by February, I believe, of 2021. And we did. We did not produce all the documents that the plaintiff wanted. Much of the documentation that they wanted related to plaintiffs who were ultimately dismissed. That was part of our objections. The plaintiffs never brought a motion to compel. They never addressed in writing in any way any of our objections. So did we respond to discovery? Yes, we did. Did we produce the documents that the plaintiff wanted? No, we didn't.
Well, but you said they didn't move to compel, but they ultimately moved to strike your answers because of your failure to comply, right?
Correct, but there was no detail in what they were seeking. They alleged that we never responded to discovery in any way, which the court found to be false. I mean, issuing objections to discovery is responding.
So they were never ruled on? None of those objections were not ruled on? Okay, this is too broad, this is okay, this is all right?
It was never raised to the court. And in fact,
said you raised objections, but that was...
I raised objections to her discovery, and ultimately, that's not really before the court what the plaintiffs produced to us or not, and ultimately 2 of the defendants were dismissed, and so discovery as to them never really moved anywhere. But the plaintiffs never moved to compel production of any particular documents. They never took objection to any of our objections or responses. They just sort of took them and said, well, we didn't get what we want, and so we want to strike the answers. And the court...
But is there a court rule that says you have to make one kind of motion before you make another? Why? I mean, they didn't agree with your objections, and then they ultimately moved to strike your answer. Why isn't that
correct? And the court...
Why isn't that an appropriate litigation strategy?
Because the court below never had before it, even in the motion to strike, it's not a question of just a different context using a different rule or different motion. The plaintiffs never made any arguments whatsoever that any of our objections were improper.
What requires them to do that before moving to strike?
It just means that they can't establish the basis to move a strike and answer. If somebody issues 10
if the court below, I mean, obviously the court below didn't share your concern that they should have made the other motion first.
But the court also didn't strike the answers because the court had before it, I think our objections became part of the record at some point, but it was never raised. And in fact, we moved to vacate the note of issue because we thought there was numerous discovery issues outstanding. We never got discovery into several of our counterclaims as well.
So, counsel, but it is true that the preliminary conference order dated February 9th of 2021 said produce all outstanding discovery by March 12th of 2021, right?
Correct. Correct. That we hadn't objected to. The court never ruled what we had to produce or what we didn't have to produce.
You just mentioned that you moved to strike the note of issue. Where's the case at below?
I think the court denied that motion to vacate the note of issue, and it's just set for trial. There's no trial date yet, but the note of issue has been filed and accepted.
Okay, thank you, counsel. I know you didn't really get to talk, either of you, to talk about the second motion.
Well, first of all, I'd like to point out that on the motion for...
You filed a note of issue on this case with the discovery situation?
Yes, Your Honor. After 3 years of litigation with nothing sensible to rely on, it was time to move forward. I had given over 500...
Was after Judge Billings, that was after Judge Billings' order, or before?
Yes, yes, Your Honor. I wanted to note that on the motion for re-argument and renewal, which I have added to the case, the entire state of the record is as represented by the plaintiffs because the defendants put in no briefs or affidavits. So the fact that they did not give over any discovery and exactly what was done with respect to the discovery is the state of the record on the motions for renewals and re-argument. That's why I put those into the record. That's the current state of the record, that there was absolutely no discovery, substantive discovery provided to the plaintiffs.
I'm sorry, so what specifically at this point is it that you need from them?
I have no discovery whatsoever. I need a case to put on. And if I have not been given a case to put on, I need plain old judgment on liability, period. This is called for by the Court of Appeals in the Kyle case that I cited to the court and the Fish and Richardson court from this court.
So if
That's
the
plainly what's
answer
called
is-
for.
If the answer is stricken, or alternatively, if they're not allowed to use the documents, how do you get what you want?
Well, not being allowed to use the documents is a very narrow penalty
you
for
can't-
someone
'cause
who
you-
snowballed you on one issue. This is an entire case. This is an entire case of 3 years.
No, just tell me, because
Yes.
I'm missing
Sorry.
something here.
Yes.
How do you get what you want? Under either scenario
judgment
or
on-
an alternative scenario?
Default on answers, judgment on liability, and dismissal on the counterclaims. I can't possibly fight counterclaims when he
But
hasn't put in
You
anything.
filed a note of issue, which means that at some point you're going to be going to trial.
Yes.
What evidence are you going to be presenting at that trial?
Pardon?
What evidence are you going to be presenting at that trial? I mean, you filed a note of issue, means at some point you're going to be called for trial. What are you doing when you get to trial?
Well, I personally, I only have the plaintiff's papers, and without
And you have
judgment.
the plaintiff's testimony.
Pardon?
And you have the plaintiff's testimony.
Correct, and I have complete conjecture from the other side, not enough, not good enough, no context, you're a liar, that didn't happen. I don't have full contracts in some of these cases. He negotiated a bunch of, the principal negotiated contracts and then says, and then didn't sign them. Were they in his files that he destroyed? Is he going to argue that the copies of contracts that we have weren't the final contracts?
Well,
Of course.
presumably, you're going to ask for a missing document charge at that point. If you go to trial and you don't have the documents, you're going to have your
After
plaintiff's
3
testimony.
years, with respect, Your Honor, after 3 years of litigation, I have now got to go back and argue the whole point that, oh, I didn't get documents for this and I'm owed that for every single issue that comes up. She didn't even find that he hadn't, in fact, given me any documents. She just gave an if no documents, then that's the result. But that's the status quo in ab initio in every litigation. If you don't supply documents in litigation, you don't get to use them. How is that helpful to me? That is not helpful to me. That is the status quo of every litigation. We are at the end of 3 years of litigation. I've been stonewalled entirely all the way. I have fought 2 removal actions that he threw up to try and avoid litigation. I had to get them remanded. And then when they came back, he still ignored them. And then he said, oh, well, I was thinking of bringing dismissal motions, so those would have been stayed. Never mind that all the orders said nothing has been stayed. And he never even moved to dismiss the main defendants, the main corporate defendant, the defendant's group, or those are main defendants. They were never moved to dismiss. And I never got any discovery from them either. His interrogatories, I put them in the record, the interrogatories said, I don't have to do her work, she should look through the documents. And the document responses say she
Counsel,
doesn't
I
deserve
know
these
it's an
documents.
emotional case, but it's been a very long time, so we will certainly take a look at these.
Well, I'm afraid there was a whole other, there was
Yes,
people
I'm-
dismissed from the case without any evidence whatsoever, with her
Yes,
ignoring all of the
I am
evidence.
aware of that because we did read the brief. So does anyone have any specific questions about either of those motions? Otherwise, we will go back and look
Thank
at
you.
all this
Thank you, Your
very
Honor.
carefully. Thank you both for your arguments. The next case for argument is People versus Quiles.
Good afternoon, Your Honors. May it please the Court. Marika Meese for Appellant Michael Quiles. The trial court here improperly denied Mr. Quiles' 440 motion without a hearing. This wasn't a matter of discretion for the trial court because the statute is clear that where there are facts in dispute, the court must order a hearing. And here there were both record facts and non-record facts from the counsel's affirmations and Mr. Quiles' affidavit that established disputed facts that warranted a hearing. In terms of the record facts, you had statements that these lawyers made in their opening and closing arguments where they admitted that Mr. Quiles possessed the gun. They offered no defense whatsoever to the charge. So under McCoy, they didn't have to invite the jury to actually convict on that charge. They made out every element.
Established as a fact in dispute.
It establishes that they made statements during the trial that suggested that Mr. Quiles was guilty of the charge, and then supplementing that with their affirmations where they said that they offered no defense and that their client clearly told them, did not give them permission to concede guilt. That collectively creates a factual issue in dispute.
So let me ask you a different kind of question here that bears on your argument, perhaps. What difference does that make to the extent that the defendant allegedly stated to the father that he had just shot his 5-year-old son by mistake?
What difference does it make to whether or not there was a factual dispute or whether or not?
Yes. If you have an admission, where does your argument go?
Well, he explicitly said in his affidavit that he did not give his lawyers permission to concede guilt. And the issue under McCoy
How is it that you say they conceded guilt?
They conceded that
When they opt for the justification defense, that's not conceding guilt.
they did as to the assault and attempted murder charges, but they agreed that that did not apply to the weapon possession charge.
So wasn't there,
please,
wasn't there position as to the gun that they got it away from him, that the victim was going to shoot them, or the victim's father was going to shoot, someone else was going to shoot them, and they took the gun away? That's not conceding guilt. It's temporary lawful possession, wouldn't that?
It's not, Your Honor, though, because there were no facts to support that defense. There is a legal defense of temporary unlawful possession, but it requires facts that show that you disarmed someone. Here, the defense was that 3 people had come to the block to kill Mr. Quiles and attack him, and that they had weapons, but there was no evidence that they had a gun or that Mr. Quiles disarmed them. And so that defense never would have been made out. They did ask for the charge, but it wasn't supported. Their
How
clients
is there
didn't
no
testify.
evidence if he conceded that he shot the kid?
I don't think that was ever argued as an admission in the case. One of the witnesses stated that they heard him say that to them, but that wasn't argued to be an admission by the prosecution or by anyone. But the lawyers then went and admitted to the elements of the charge, factually conceding and essentially conceding the actual guilt. And Mr. Quiles said he never gave them permission.
What is it that you want the defense counsel to do, which he didn't do, or that he did, which he shouldn't have done? What specifically is the issue that you have?
Well, they never offered any defense to this charge. They agreed that justification charge didn't apply to weapon possession. They admitted Mr. Quiles had the gun, and they offered the jury no basis on which they could have acquitted. So they created an impossible situation where he was necessarily...
So what was the basis upon which the jury could have acquitted when you look at the evidence that's present in this case?
They could have sought the lesser of 2 evils charge, which would have applied and given the jury a reason. They could have more explicitly asked for jury nullification. They could have done an alternative course, but what they did do wasn't permissible under McCoy.
Are they permitted to ask for jury nullification?
No, they aren't explicitly, but they said in their affirmations that that was their only hope, because they admitted that they never had any defense here. They had no defense to the charge. They were inviting the jury to acquit on the attempted murder and to convict. And that brings up the Strong issue. The Fourth Department's decision in Strong is just wrongly decided. There's no reason to limit McCoy to a top count charge. In fact, in McCoy itself, it wasn't a top charge.
What would you do with the video in this case? As you're saying that defense counsel offered no defense, what was supposed to be done with, what was defense counsel supposed to do with the video?
I'm not sure exactly what Your Honor means in terms of the video, what was depicted in the video?
Well, you have the defendant walking down the block, is he not, with a gun in hand?
I don't think that's in the video, Your Honor. There is 3 people who come to approach him, who pull up their hoods and approach him in a menacing manner. And then you see him sort of running away with his hand in his pocket.
But you see things before he puts his hand in his pocket, one hand is bandaged, right?
One hand is in a cast and a bandage.
And what's in his hand certainly looks like a gun, which he then puts in his pocket as he's passing the father and the child and says something to the father. I mean, this is the evidence that defense counsel had to work with, isn't it?
I disagree that you could clearly see see a gun in the hand. The people argue that there was an inference that there was a gun, there's a hand put in the pocket.
What do you suggest was in his hand as seen in the video?
It could have been numerous other innocuous objects that are similar in shape, a cell phone, a wallet. You just can't tell definitively.
And if counsel were to make unreasonable arguments to the jury regarding that, wouldn't they run the risk of reducing their credibility with the jury to get the other top counts, acquittals on those top counts?
I'm not suggesting they should have made those arguments. I'm suggesting they should have either sought a justification charge that would have applied to the gun, or they should have gotten Mr. Keela's explicit permission to concede guilt in the way that they did. Because they didn't, this case falls cleanly under McCoy, and the court should have granted a hearing to explore those facts further or to give further consideration.
Thank you, counsel. Thank you. Time in response.
Good afternoon, and may it please the court. Paul Anderson for the people. To borrow Justice Higgitt's idiom, to get a hearing on this, you have to allege fire, and they didn't even allege smoke. These were very crafty, or very well-crafted affirmations from counsel, very well-crafted affidavits from defendant that doesn't go as far as what counsel is arguing, that no attorney ever affirmed that my only defense that I came to this case and my only defense was jury nullification. They just alleged at some point they were hoping the jury would nullify the verdict. And of course they couldn't go that extra step because the clear record evidence shows that they went into opening, prepping, and setting the stage for a temporary and lawful possession. Mr. Keeles didn't bring the guns to 167th Street. And so that's exactly under People v. Williams in the Court of Appeals, an option that you can use for temporary and lawful possession. And then later on, when they applied for the charge, it's put on the record that they tried to get the charge, and it was an off-record conference, but it was put back on the record. And once again, that the charge was denied and that they were left having to keep going with the case. That doesn't mean they conceded guilt. And if you look at the closing, again, he's sorry, but he's not guilty. And so once again, there is no way that this was an explicit concession in what the Supreme Court contemplated in McCoy. And let's think that why that's important, because McCoy isn't just an ineffective assistance of counsel case, it's a total deprivation of counsel case. So there would be no prejudice prong here. And I think that's why that's why defendant wants this under that McCoy umbrella. And that's just simply not the case here. And that's why the court just read the record, was actually the same judge at the trial, and realized there was no concession here. I don't have to go further. And in the alternative, under Strong, really McCoy is a narrow set of cases to top count. But again, because that court made that finding, we don't really need to reach that issue.
What we have here is that counsel achieves getting justification charged.
Yes.
When the victim is a 5-year-old child.
Yes, which is, it was a good result for Mr. Keeles in that regard, in that here was a case with a very sympathetic victim in which there was no way to make a misidentification defense. This wasn't just a video here. It was the 5-year-old's father knew Mr. Keeles from the neighborhood as White Mike. As Mr. Keeles is running by, he says, "Sorry, Charlie," the father's name. And also to the idea that
Actually, it comes out as a rather extraordinary success for defense counsel, does it not?
It does, and in fact, if you
having achieved an acquittal on the attempted murder.
Yes, and in the case where really there was no, arguably, I can't fight with the jury's verdict, but if you look at the pizzeria video, no one was armed or visibly armed. I think the person has a cigarello in his hand. And if you actually look at, I reread defendant's affidavit here, he said that his attorneys were surprised that the jury found him guilty of weapons possession. I mean, I think that could also be his counsels were surprised that the jury found him innocent or not guilty of the assault one and attempted murder. But once again here, all of these affidavits come together to show that this was a strong dialogue between counsels and defendant. They talked together about this strategy, and they never conceded guilt. And to the idea that the lesser of two evils defense should have applied, it doesn't. This is on a collateral attack of a conviction. If this was something that would come up normally for weapons possession, this court and many other courts would have had robust case law discussing this. And given the Court of Appeals decision in Williams, there is no justification for weapons possession. It's just temporary and lawful possession. And if your honors have no further questions, I ask that you affirm. Thank you.
Thank you.
A good result here doesn't preclude a McCoy claim where the lawyers conceded guilt impermissibly without their client's consent. I agree that Mr. Quiles obtained a good result based on the facts of this case, but I do not think that precludes a McCoy claim, and there were enough factual disputes here that a hearing should have been granted. As I noted before, I think this court should address the Strong issue because the Fourth Department case is the only one out here, and it's wrongly decided. There's no reason to limit McCoy to a top count concession, so I'd ask this court to address that issue. To Your Honor's question earlier about whether there was an admission, I think that we just clarified on the record that what he did was run by and say, I'm sorry, but he never said, I shot. So whether there's an implicit admission there or something, but that was not part of the record, that there was an admission of any kind that he shot Jaheim. And just briefly on these sentence here, I know that
He did say more than, I'm sorry, though. He said, to my fault, right?
I think, no, he just said, I'm sorry, I believe. And just quickly on the sentencing, Your Honors, I believe the minimum sentence is appropriate here, given that the jury found that Mr. Quiles was justified, and there were mitigating facts that he was protecting himself and defending himself against 3 people who came to kill him, and other mitigating facts in his favor. Thank you, Your Honors.
Thank you. Thank you both. The next case is Harmon CS versus Ginu, and Justice Gonzalez is recused from this case. Yes, please have a seat, and then you don't have, and then you can go to the podium, okay?
Thank you.
You're welcome.
Good afternoon. May it please the court. My name is James F. Simmermeyer II from the law offices of James F. Simmermeyer, PC, for the appellant. This appeal is based on numerous procedural and factual errors made by the family court. Judge Shim's June 16, 2022 confirmation of a finding of willfulness failed to identify the support magistrate and relied on a non-existing support magistrate hearing of January 1st, 2000. This date.
But everybody knows that there was a hearing before the support magistrate, not on that date. No one disputes that, right? Is there any dispute that there had been a hearing before the support magistrate on a different date?
Well, yes, there was a hearing before a support magistrate, but I don't think the burden should be.
Did anybody move to modify the order based on the error in the record, error in the decision?
No, Your Honor. And I was retained after this decision. I wasn't the trial.
I wasn't trying to hold you or someone else responsible. I was just trying to find out.
Okay.
No one tried to correct that, though.
Understood. No one tried to correct the order, but I don't think that's the obligation of my client to jump into the state of mind of Justice Shim. All we have is a decision to work with, and within that decision is that date, and he makes references on the record generally to a file, and that file does not. It's not clear what he relied on, what the basis of that decision is. Now, after perfecting the appeal and the filing of respondent's brief, right, the subpoenaed file from the family court was finally uploaded 6 months later on April 21st, and mysteriously a second order appeared with a different date of, I believe, September of 2018. Now, that order, there was no knowledge from appellant or respondent of that order. And that also, and the language in that order doesn't state that this order corrects the previous order or supersedes that order. So now we have 2 orders up in the air. And that order, there was no service, and it didn't comply with the Family Court Act 1113, which requires the notification on the bottom with the checks indicating who and how it was served. Neither of these orders did that. So, and then on top of everything, if we look in the transcript, Judge Shim also relies on Judge Bolt's prior decision, and there's no, in the record, there is no decision by Judge Bolt. In fact, a clerk from this court contacted both counsel and I requesting this decision, and none of us have it. So the record is incomplete. I believe that the record supports reversal, and remanded back to Judge Shim for a complete hearing and what his basis is for this decision if he continues in finding willfulness against appellant. I have no further
Okay.
argument.
Okay, thank you. We'll hear from your adversary, and you'll have a few minutes to respond. Thank you.
May it please the court, my name is Andrew Baer, and I represent the petitioner respondent Carmen S. in this matter. The order that we're talking about.
Could you address the procedural, alleged procedural irregularities that counsel discussed, Mr. Baer?
So there was never a record filed in this case. The only thing that was before the court filed with the appellant's brief was a transcript from 6/16/2022 and this order that we just talked about, which gave an incorrect date of the children's birthdays and when this proceeding before the support magistrate was entered. Subsequent to my filing of the brief, the following day on NISF, all of a sudden appears the file from the family court. I raised in my brief that the record was insufficient in this case. But again, the day after I filed my brief, that record is now before this court and filed on NISF. I review that record and find that there is an amended order. Obviously, the court realizing that the order of confirmation that it made was incorrect in regards to the children's birth dates and to the date that the support magistrate hearing was held. And so there is actually an amended order in the record, which gives the correct dates for the children's birthdays and of when the support magistrate made her finding of willfulness. So that's the procedural aspect of the case. So that is all before. Now this order is also, Judge Shim's order is an order confirming the willfulness. In that order, Judge Shim reduces actually a prior order which gave a purge amount of $100,000 to $50,000. And he commented on it that that was very rare for him to do, but that's what he did. The order does not enter any kind of order of incarceration. There's never been an order of incarceration in this matter. Essentially, the judge said, we're going to hold this in abeyance. We're going to let the appellant try and pay some money, pay the purge amount, show compliance. We're going to come back in 6 months, and in 6 months, if he hasn't paid, well, then the court's going to seriously think about incarcerating him. And so what happened was a day or two before the 6 months were up, counsel came and asked for a stay. A stay was granted. The appeal was filed. And here we are today. The bottom line is, in this case, both appellant's counsel and myself agree this case has to go back before the family court because the judge in the family court is going to look and see whether there's compliance or not and ultimately determine what is the proper sanction for this court to continue the purge amount. And if, again, the court thinks it is appropriate and the court has total discretion as to what sanctions are appropriate, the court can enter an order of incarceration. This is a case where the appellant is in arrears of over $250,000. This isn't something that just happened recently. This is a long-standing case where the appellant has failed to pay support of his children.
A lot of that's interest, isn't it? Some of that interest?
Some of that is interest, but there's a good portion of it that is actually the basic support. So it's just interesting that we're here because the bottom line is whether this court really affirms, whether it dismisses the appeal, or whether it reverses, this case is going to go back to the family court because the family court has to ultimately determine what sanctions are appropriate on the finding of willfulness by the support magistrate.
Is it a problem that we're missing the findings from the support magistrate?
We're not missing the findings from the support magistrate. They are in the record. They are there. As a matter of fact, if you,
are they in a formal order or not?
They are in a formal order. Actually, attached to my brief as an appendix is actually the original order of the support magistrate.
And what's the date of that order? What's the date of that order?
I have to look into the date of that order is.
All right. Well, if it's attached to your brief, I'll.
December 6, 2019. I would also point. Yes, December 6, 2019. And it actually refers, well, that's the order that was ultimately made. The original order was September 13th, 2018. And I would ask the court to look at both of those orders. Because the second order that I'm referring to, believe it or not, when the appellant made an admission before the support magistrate to willfulness. So once he made an admission.
When was that? I tried to find that in the record and had trouble with that. I mean, the record, it's not exactly paginated easily, so I was just curious if you could give me some guidance.
I believe it was from that September 13th, 2018 order. And what
It's from
happened?
the order, but is there a transcript?
Well,
excuse me.
I apologize.
Okay, I saw in the order where the family court judge that the father consented. Is there a transcript in the record anywhere where the father actually consented?
Again, what I argued first off in my brief was that the record here was insufficient because none of the transcripts from all the prior proceedings are before this court. There was only
So
one.
am I correct that in none of the transcripts in front of us is, as far as I could tell from the transcripts in front of us, I couldn't find an admission by the father. And can you point me to anything that I could find, where I could find that?
Again, I believe that the September 13th, 2018 order states that he made.
Not the order, a transcript.
Well, I believe there is a transcript, but again, it was never produced, and I believe it's from September 13th, 2018. And again, I argued that the record was insufficient in this case, because we should have all this before us, and to obviously, flush out these questions. And obviously, we can't with an improper record or an incomplete record. That's
You don't have a date back in family court because it stayed pending the resolution?
There actually is a date in family court. I don't know what it is. I know it's coming up in a month. There's been a number of proceedings that have occurred, and the court basically says, we're waiting for this appeal to be decided. I can't do anything with it. I do believe, by the way, though, it's going back before another different judge. This will be the fourth judge.
Well, that's another issue.
I will just state, though, that, and I apologize, I know that
You have 30 seconds.
that after the appellant made an admission, he consented to probation and a term of various amounts of support. And then he still, even after agreeing to that and making the admission, he still continued to violate and not pay the amount. It makes no sense why a person would agree to pay an amount of support if they knew they couldn't pay it and agree to probation, and that's what happened. They violated him on probation, and then we ended up back here. Thank you very much, Your Honors. I appreciate the time.
Counsel, you have 2 minutes to respond.
I think counsel here agrees that it needs to go back to the family court, but except in his briefs, he's shifting the blame onto the appellant. But if the First Department can't obtain a complete record from the family court, how is an individual lawyer going to obtain a complete record if they don't have it? So I believe that the record supports a reversal and a remand back to...
Did you make an effort to get any of the record from family court?
Yes, I obtained the records from my client, what he gave me, and from trial counsel.
From the family court itself.
Well, no.
Okay.
But this appeal was done by the appendix method, and the subpoena was issued by this court. So we have the supplemental record for the court, and that's what the family court gave this court. And I think the record supports that it should be remanded back to the judge and for reversal of this order.
Okay, thank you.
Thank you.
Thank you both. Okay, Maknovich versus the Board of Managers. You may step up to the podium.
Good afternoon, Your Honors. My name is Stacy Maknovich. I'm the plaintiff appellant. May it please the court. Your Honors, I believe it is important to let the court know that a few days ago, by the order of the U.S. Court of Appeals for the Second Circuit, and after the court heard the oral argument between the parties were ordered to appear for camp mediation program, and it was further ordered that a counsel be appointed to represent me at the mediation conference, and I do have the court order. As counsel, Mazzola be equally attending, representing the defendants, and as the issues presented are echo the issues presented here and presented in state court, I believe it is important to mention this fact on record here in this court. Now, this action is about these defendants' intentional and malicious failure to take any corrective actions, as they simply have been evading my complaints for years. Their failure to properly investigate, inspect, correct, take responsibility for spontaneous ceiling collapses that resulted out of structural defect, and as other tenants experience, and as happened in my apartment, and as these defendants had specific knowledge of for years, but failed to correct, and as they push a regular consumer like myself into exhaustive submission. In fact, Your Honors, a few weeks ago, I learned there's another person, another victim in my building who had experienced exactly the same thing.
Ma'am, what do you feel is the strongest legal basis for us to reverse Justice Leibowitz's underlying orders?
Yes, Your Honor, I believe that I should be able to find resolutions because, Your Honors, what happened, I filed my counterclaim in state court and my was dismissed, and then I filed my claims in federal court. It was dismissed without prejudice to be refiled in this court, and then it was dismissed for lack of personal jurisdiction. And I believe that I should be able to find resolutions and to find corrective measures and to be able to have this resolved. Your Honor, this particular appeal...
Your claim is primarily based upon events that happened in 2008 and 2013?
It's still not being corrected. The spontaneous ceiling collapses happened as a result of the structural defect in the building. It's not just in my apartment, it's everywhere. And the defendants know about this defect. They are aware of it. In fact, when we approached, myself and this other tenant approach the management and Grace Bishop, who is I believe, a legitimate board president. But in any case, as we approached them 2 weeks ago, we were told that the spontaneous ceiling collapses result out of vibrations of the busy intersection of Ocean Avenue and Avenue 1.
But let me just I'm not disputing that this happened 10 years ago. But we're here now we have a decision from a court in the Supreme Court who dismissed your case for various reasons. We have to understand if any of those reasons are wrong, so you would like us to reinstate your case, I presume, but there's a lot of statute of limitations, you didn't serve things right, and how do you deal with those issues? Because those are procedural issues we have to get to in order to get to the heart, the meat of your case.
Yes, Your Honor. So the board was dismissed for lack of personal jurisdiction. Now, I understand that I can refile based on the fact that the same claims were pending in federal court, and they're still pending the appeal, and I believe I have 6 months to refile the action. Now, the issue is with the managing agent. Now, the trial court previously sustained the fraud claim against defendant Selzer, who is the managing agent, and that was sustained on March 12th of 2021. And then it was dismissed, the defendant Selzer was dismissed from the action in July. It was after the defendant Selzer filed notice of entry, filed her answer, filed a notice of deposition. I arranged my schedule to attend the depositions, and then I, of course, scheduled her deposition so I can request all the accounting from her. After that happened, the court dismissed defendant Selzer from the action without providing the notice and without explaining why that happened. And I would like to cure, if there are any deficiencies that I need to cure or anything that I need to provide, I would like to have an opportunity to do so, Your Honors.
Okay, let's hear from your adversary and we'll give you a few minutes to respond. Thank you very much.
Good afternoon, Your Honors. May it please the court, Brian Mazzola on behalf of the respondents. So I think the court hit the nail on the head that the issue here is not the various complaints that the plaintiff has. Those are not before this court. What's before this court is that the complaint was dismissed. Judge Leibovitz made an error in issuing some decisions where he referenced oral argument and then vacated those decisions and then made a decision as to Ms. Sulzer on the record and explained very, in depth and thoroughly why the complaint should not proceed against her, including the fraud claim, in that she didn't plead it properly. The complaint is very generic. It only states that the defendants, with an S, made representations to her, which induced her to pay her common charges. So not only does Sulzer not have a duty to the plaintiff, but the representations that she's referencing are within the bylaws. She's obligated to pay the common charges. There's no reasonable reliance. I don't believe that the plaintiff is challenging the merits of the dismissal of the rest of the claims. And there's no question here that she sued a condominium, and she didn't serve the condominium properly. She served the former paralegal who worked for the former managing agent. And she's required, given that it's a condominium, to serve the president or the treasurer, and to also name the president and the treasurer as a defendant in the action. So I don't see that there's anything in the record that has been put forward and justifies overturning the decision below. It's correct, and I believe it should be affirmed.
Any questions?
If there's no questions, I'll rest on the record.
Okay, thank you.
Thank you.
I'll give you a few moments to respond.
Your Honors, there is nothing in the order dated March 12th that states that the court denied defendant Sulzer's motion to dismiss as to the fraud claim. There's nothing about the oral argument in that order. That was decided based on the submission. March 12th order does not mention anything about the oral argument at all. And I believe that dismissing the action without giving me an opportunity to correct whatever defect there is something that I should be, is something that I would like to correct if I have an ability to. And I believe that dismissing the action without an opportunity to correct is something that should be provided to me, and I believe that an extreme sanction of dismissing the action without providing this opportunity is unwarranted in this action.
Okay, we will look at some of these points that you both made, and I thank you very much for coming in.
Thank you, Your Honors.
Good afternoon. Southern Advanced Materials versus Abrams.
Good afternoon, Your Honors. May it please the court. I'm Megan Shea, and I'm here on behalf of defendant, appellant, and respondent Robert Abrams. This case arises out of the sale of a company called CV Holdings.
Judge Masley, in denying your motion for summary judgment, pointed to Delaware Code 278, Section 278, about allowing 3 years for dissolution. What's your cast on that statute in terms of this case?
That is the correct statute. A dissolved company is allowed to continue for 3 years to shut down its affairs. That statute.
Let me recast my question. Why doesn't that mean there wasn't a dissolution here? Because you've got to allow 3 years.
It means it wasn't a dissolution here because that never happened. The company is, the statute allows a dissolved company to continue its operations for 3 years just to make sure they can get all the wind-up procedures effectuated. It expressly prohibits the company from continuing its operations. And so does this.
Every company dissolving is into this 3-year period post-dissolution, right?
Correct, to wind up their affairs, which means, selling and liquidating assets, making final distributions. The point that's extremely important and what was missed by the court below, and this is on the breach of contract claim, is this operating agreement provision that Sam seeks to invoke to get a preferred return says, if CVH disposes of substantially all of its assets, the preferred shareholders would get a preferred return if the value of the assets that remain after the transaction wouldn't provide those shareholders with a 30% return on their investment.
Just to step back for a moment, was there and I understand you completed the alternative, but was there an inconsistency in the plaintiff's position in the breach of fiduciary duty, that you breach your fiduciary duty and not in Abrams not arranging this in a way which made certain that the plaintiff received the preferred value, and in the breach of contract cause of action, that this is in fact a dissolution?
That's exactly right, Your Honor. Sam is arguing two separate sides of a coin, two opposite inconsistent sides of a coin. Sam argues, because there is no dispute, that Wendell purchased 100% of the shares of the company. So Sam asserts a breach of fiduciary duty claim, arguing that Abrams breached his fiduciary duties because he structured the sale as a stock sale in order to deprive Sam of its preferred return. Then Sam argued, but also Abrams breached the contract because by not paying Sam a preferred return because the sale to Wendell was not a stock sale, it was actually a dissolution of the company. And so those are two very inconsistent. That's not just alternate pleadings. That's taking two inconsistent, irreconcilable positions. But on the breach of contract, what the point that keeps getting missed here, and a gap that Sam cannot fill, is this dissolution provision doesn't apply if, as Sam argues, that it was a dissolution because at the end of the day, all of CVH's assets were disposed of. There was nothing left. This provision cannot apply under those circumstances. This provision says CVH dissolves if it disposes of substantially all, not all. And that is a critical distinction. Under the Delaware standard, a company disposes of substantially all of its assets if it disposes of its core operating assets such that the ability of the company that remains after the transaction to continue operations is in question, which means after the transaction, there's a company intact, now devoid of its profit-generating assets. The dissolution provision is exactly consistent with that. This provision says, upon disposition of substantially all of its assets, the manager must immediately proceed to wind up the affairs of the company. It means there must be a company left. Those wind-ups include selling and liquidating remaining assets. We don't have any assets.
So when you say, as Supreme Court did in denying your motion, that there is an issue of fact as opposed to an issue of law, what is the issue of fact that you would take in front of a trier of fact? And I note, as from my reading, no one contends that this agreement is ambiguous. Both sides agree that it's clear.
You are exactly right.
So what would be the issue?
That is why we raced up here on this appeal, because there is no issue fact. Sam is not even attempting to say this transaction fits the terms of the operating agreement provision. Sam is not arguing that CVH disposed of substantially all. Sam is arguing everything was gone. This contract has a provision when the company is sold. It's a separate provision which says the shareholders, when the company is sold in a stock sale, as it was, the shareholders take their pro rata share. They are not entitled to preferred return. This dissolution provision does not apply unless something less than all is disposed of. And that every section refers to wind-up procedures, selling and liquidated assets. The preferred return that Sam wants here is only able to be calculated pursuant to the terms by assessing the value of the assets that remain. You're supposed to assess what's left. Does that provide them with a 30% return on their investment? If not, you get a 10% preferred return. You got to read this transaction. It cannot possibly apply when the company is sold.
Counsel,
and one more point I know.
I didn't mean, were you done with your answer to Justice
Yes.
Breyer's question? Okay. I have a related question. It seems to me that part of your argument is that CVH continued to exist, but I looked in the record and couldn't really find any evidence that CVH continued to exist after the sale. Well, could you point me to where that evidence is in the record? I'm not saying it's not there. I couldn't find it. It's a voluminous record, and I looked.
Well, two things. If CVH was dissolved.
No, actually, I'd really like to know if you could pinpoint me towards somewhere in the record that shows that CVH continued to exist for 3 years after the sale to Wendell.
cited in our briefs, I just have to find it, the testimony of John Belfance. This was the executive.
Testimony of?
John Belfance. This is the executive that ran the company before it was sold. That executive went over with Wendell and talked all about what he did to the company to build its value, because it was then resold later on to a third party called Aptar, resold for more money. So he gives all this testimony about the things that he did. And Sam's only evidence that it was dissolved is the fact that Wendell referred to the company after the transaction as CSP. The buying entity that Wendell created was called CSP Technologies. That's the entity it created to buy CVH. Of course, Wendell called it CSP after the transaction, and that is not evidence that a company was dissolved. But one more point on this. The dissolution provision talks about a transaction where the manager still owns the company. The manager is required to wind it down. In this transaction, everyone sold to Wendell. There was nothing left. We have a provision in the operating agreement that applies when the company is sold. It's not the dissolution provision.
On a somewhat different note, and I think this really goes to the breach of fiduciary duty claim, isn't it accurate that Mr. Abrams' attorney's November 11th, 2014 letter to Sam's was untrue when it said that everyone except Sam's had agreed to the sale to Wendell?
At the time of this, there's still questions of fact, but there might have been one other shareholder that they were still negotiating with, but...
So it wasn't completely true that what he said in that letter?
Chronologically, there were still negotiations happening. This letter was written by Abrams' counsel, not backing away from it, but chronologically, there was still another shareholder that was...
So it wasn't true?
So it was not true, but can I get to that point, or do I have to wait?
No.
This is the breach of fiduciary duty claim.
Find out if it was true.
On the breach of fiduciary duty claim, Sam argued, as Your Honor pointed out, that Abrams breached its fiduciary duty because it structured this sale as a stock sale, and intentionally to deprive them of Sam of their preferred return. The Supreme Court properly held that Abrams does not owe fiduciary duties to ensure Sam its contractual right to a preferred return. On this appeal, Sam is not disputing that ruling. Sam is arguing only that Abrams breached duties of disclosure in seeking Sam's consent to the sale. And that's where Your Honor was going with the misrepresentations.
Okay, can you just
Yes.
wind it up?
Abrams did not owe. When the parties negotiated Sam's consent to the sale, Abrams was not acting as a fiduciary. Sam knew it. And in fact, the parties made express
This
in their
business was
agreement.
sold, was it sold for $360 million? Was that the number?
Excuse me?
The sale price was $360 million, right? I mean, Abrams' interest and a plaintiff's interest are, as to getting this preferred amount, are clearly in conflict. I mean, from the get-go, they are not on the same side they don't have consistent interest. If plaintiff gets more, Abrams is getting less. If Abrams gets more, I mean, in terms of that being a fiduciary duty, why would the plaintiff think that Abrams is his fiduciary in this?
I'm going to answer that with 2 points. First, under Delaware law, a fiduciary is not obligated to structure a transaction in a way designed to afford the preferred shareholders their contractual rights. Second, Sam knew Abrams wasn't acting as a fiduciary and wanted it that way. The settlement agreement that they negotiated expressly makes clear that Abrams is acting as an individual, and Abrams is required to assume personal liability for Sam's claims against the company to pursue more money from the sale. That was the purpose of that agreement. Sam secured its right to go after Abrams individually.
They gave up other potential settlement options in order for plaintiff to take its chance to bring this lawsuit against Abrams, right?
Correct, but those options were not rights afforded to Sam under the operating agreement. They were bargaining outside the operating agreement.
That was the settlement. This was coming to a conclusion as to what's going to happen. There were three options granted, I think, and plaintiff took the option, well, we'll take our chances on suing Abrams.
Correct. None of those options were afforded to them under the operating agreement. They were negotiating outside the confines of the agreement that governs his investment.
That's post-operating agreement. That's post-operating
Correct, but that goes to the point that these parties were operating outside the confines of this fiduciary relationship. And last, on the breach of the duty of disclosure, which is the only element that's being advanced here, Sam has not proven any damages caused by any purported breaches of the duty of disclosure. Below, Sam argued that had it known it wasn't the last shareholder to consent to the sale, it would have continued to demand payment from Abrams. Sam is ignoring that it reserved the right to pursue Abrams in litigation to continue to demand payment, which is exactly what it's doing here.
Okay, let's hear from your adversary. You have a few moments to respond. Thank you, Counselor.
Thank you, Your Honors. My name is Amiad Kushner from Side and Law, and I'm counsel for Southern Advanced Materials, the respondent appellant, and I'll refer to.
But I wanted to ask you, it's your position, obviously, that CVH was dissolved.
Yes.
If this was a dissolution, why did Wendell, in continuing to operate the company after the transaction, so the purchase agreement provides, it includes an earn-out provision that required Wendell to pay Abrams certain earn-out payments if the earnings of the company reached certain thresholds during a 3-year period from 2015 to 2017. Now, why, if this was a dissolution, is there a requirement for Wendell to pay Abrams additional sums?
The earn-out provision in the purchase agreement has absolutely no bearing on the dissolution provision of the operating agreement. 2 different contracts,
But
2 different parties.
Is it not reflective of whether we're dealing with a dissolution or not?
No, it doesn't, Your Honor, because in this particular dissolution, it just so happened that Wendell ended up with substantially most of the assets, including the operating assets of
Still running the company.
It did end up, we're not disputing that the entity CVH continued to exist. We think that's legally irrelevant, but the entity continued to exist. Our position is that under Section 13.1 of the operating agreement, that entity was dissolved.
So let me ask you, Judge Masley finds on Abrams' motion for summary judgment that there's an issue of fact as opposed to an issue of law. What do you see as the issue of fact for trial presented?
Look, admittedly, I think Justice Masley's opinion is not crystal clear on that point. She did say in her opinion that she can't just take assertions that all the assets were disposed of. She needs evidence. My personal interpretation of it is that she wants a clean record where witnesses, could be fact witnesses, could be expert witnesses, come in and say, look, these are the assets that were disposed of in the pre-closing restructuring. And maybe this is how valuable they were. And in the Wendell sale, the second step, these are the assets that were disposed of.
Well, don't we know the terms of the transaction? There was the pre-closing and then the next day the actual closing. We know what happens to the assets. We've got the operating agreement. Both sides agree that the operating agreement is clear. What is it that a fact finder is going to decide?
Your Honor, we agree with you. Sam's position is that there is no issue of fact.
You should get summary
We should get summary judgment. You just asked me, what did Justice Masley mean? I'm trying to tell you what I think she means, but frankly,
You don't really
she got
think
it
that
wrong.
there's an issue of fact?
We don't see any issue of fact. All the assets were disposed of.
It's a question of law.
Absolutely, Your Honor. Justice Friedman, I wanted to go back to a couple of questions you had in the opening. You had asked whether there was an inconsistency between Sam's position on the fiduciary breach claim and Sam's position on the contract claim. And you're right that as originally pled, there was arguably an inconsistency between, on the one hand, saying you breached, Abrams breached.
Please remember that I said you can have inconsistent pleadings.
Absolutely. And
Alternative, I mean.
Yeah. Part of the fiduciary breach claim was that, as originally pled, was that Abrams frustrated Sam's right to receive the preferred return by structuring the deal in a way that we wouldn't get the preferred return. But on appeal, we're not arguing that anymore. But critically, the fiduciary breach claim is much broader than that. Even as originally pled, it includes inadequate process, unfair allocation of proceeds, unfair price, and the fiduciary duties of care, loyalty, are owed equally to common and preferred shareholders. So for example, both common and preferred shareholders have a right to get truthful communications from fiduciaries when fiduciaries asked ask for consent to a sale of the company. Both common and preferred have the same right to get truthful information. They have the same right to get a fair allocation of proceeds. So one of the things we alleged in the complaint was that Abrams just distributed a lot of assets to himself in the first step of this two-step transaction, but we didn't get our pro rata share of the proceeds. We didn't get any accounting of what we're entitled to from SIO2, which was being valued at several
So
hundred.
what happened to that claim? Wasn't there some further negotiation about that, and the amount that you received was increased?
Absolutely, Your Honor, but
Did it go from 25 million to 31 million?
there was some negotiation, and as Your Honor pointed out in the opening, it ended up in a retained claims agreement, but critically, Your Honors, the retained claims agreement is not a settlement agreement. It's not a settlement. Nothing was released. If you look at the definition of retained claims, which is what we're bringing here, Abrams assumed everything.
Well, you clearly retained the right to sue.
It's not simply that we retained the right to sue. We retained all of our claims. Nothing was released. Look, I understand that, counsel for Abrams has labeled it as a settlement agreement, but Your Honors can take a look at that document. Nothing is released.
It's not a release, it's a reservation.
Absolutely, Your Honors. I'll reserve the balance of my time unless you have questions.
Thank you.
I'll be brief. Counsel got up here and answered your question saying Sam admits that the company continued to exist, but that it's still a dissolution under the provision they're invoking in the operating agreement. The operating agreement expressly states that upon dissolution, the company must cease operations. That's the provision they're seeking to invoke here. As to the
Cease operations within the meaning of Delaware law, which means to wind up within 3 years.
wind up, they have to wind up the affairs of the company, which must still exist, owned by Abrams and the shareholders. Obviously, that's not the case. They must sell and liquidate remaining assets. Sam admits there were no assets left, and cease operations. Sam talked about this, that their fiduciary duty claim is broader than this duty of disclosure, that it includes unfair process, unfair price. We don't get to entire fairness until Sam proves that Abrams owed it a fiduciary duty. We've argued that Abrams, and the only claim they're advancing on appeal here is that Abrams breached fiduciary duties of disclosure. You have our position on that Abrams was not acting in a fiduciary capacity. More importantly, this reply brief, one of Sam's briefs, talks on and on about the unfair price that Wendell paid to acquire CVH. The fiduciary duty claim that Sam pursued below never alleged or argued that the price that Wendell paid for CVH was unfair. Sam's argument on summary judgment was that there were issues of fact as to fair price because Abrams negotiated payments to the shareholders about the amount they would receive from the Wendell proceeds. There was no argument about the price that Wendell paid, which is the only inquiry in a fair price analysis. We don't get to the entire fairness standard in this case. The sale to Wendell is a third-party sale. Sam talks about competition with the shareholders in its brief. It doesn't cite any case law, and the case law is clear in Delaware that the Delaware courts find the shareholders competed with the shareholders sufficient to warrant entire fairness review in 3 limited scenarios. They are set forth in the Gameco asset management case. We all cited it in our briefing for another proposition, but there's 3 discrete scenarios, none of which are identified by Sam, none of which are addressed, none of which apply. The shareholders, there's no dispute, all of the shareholders received more than their pro rata share of the proceeds. So this isn't a shareholder competition case. And last, in Sam's briefing, they argued that they are not required to prove damages caused by Abrams' supposed breach of the duty of disclosure. Sam is wrong on the law. In the cases Sam cites, including Doman versus Goodman, the Supreme Court of Delaware says this per se damages rule applies only to nominal damages, not to compensatory damages. A plaintiff shareholder is required to prove causation and damages as a result of a breach of fiduciary duty of disclosure.
Thank you.
Just briefly, Your Honors, the operating agreement.
So did the operating agreement require that upon dissolution, Abrams had to immediately proceed to wind up the affairs of the company and actually file with the Delaware Secretary of State articles of dissolution?
No, Your Honor. And I'll start by saying the operating agreement in Section
It's not
13.
in Section 13.4 of the operating
Well,
agreement?
in 13.1, I'm just starting with
13.5.
13.1, it says CVH shall be dissolved upon the disposition by CVH of substantially all of its assets. It does not say the dissolution happens when CVH ceases operations. There's nothing in the operating agreement that says that. Now, with respect to 13, Your Honor asked about 13.4?
It doesn't say in Section 13.2A that upon dissolution, the manager shall immediately proceed to wind up the affairs of the company?
Yes. So here's the way that Sam reads that. Section 13.2A and B merely require that upon a dissolution, if any remaining assets exist, the manager must wind up the company and liquidate the remaining assets. So if you look at the language, Your Honor, bear with me, if you look at 13.2A B, it says if the company is dissolved and its affairs are to be wound up. So dissolution and the wind up are two different things. There's the and there. Okay? Now, what that means is that you can have a dissolution, as occurred in this case, which is not necessarily followed by a wind up. So our argument, and again, this goes back to what you were saying about how there are no assets left. Of course, you can have a situation where a company disposes of, say, 98% of its assets. And then the remaining 2% would be wound up by the manager in a formal liquidation. But our argument here is that 100% of the assets are disposed of.
Well, in that section, in between the sentence that said, upon dissolution, an accounting shall, it says an accounting shall be made of what's there, and then the manager shall immediately proceed to wind up the affairs of the company. What else would happen? What would be the alternative here?
There's nothing that needs to happen in this instance. Again, if there are assets left in the company that need to be liquidated, then 13.2 is doing some work here.
And it's possible that there would not be.
In this, it's possible, and this is our case.
Counsel, I have a slightly different question. In your brief, you say that Mr. Abrams coerced Sam into signing a retained claims agreement. I was surprised by that because it appeared to me that your client was represented by fine counsel in negotiating that. What was the form that coercion took?
We use that term in the context of fiduciary duty law. This is not.
So it wasn't coercion. Are you claiming that there was coercion or not?
In the fiduciary context, yes.
What does that mean?
What it means
What was
is
the nature of the coercion that occurred in the fiduciary duty context?
the nature of the coercion was threatening to sue Sam for $360 million. Sam.
Threatening to sue is coercion? In
the context of a fiduciary law, yes. A fiduciary is not allowed to do that.
And what other form did the coercion take?
It was essentially the lawsuit. We're going to sue you. We're going to sue your partners, your investors, and this is a lot of money.
So threatening to sue is coercion?
It's a pretty significant threat considering the resources of Abrams.
Okay.
Yeah, I just wanted to just briefly comment.
30 seconds, sir, because you're way over your time.
Are there any other questions?
Does anybody have? I think you both have answered a lot of our questions, and I thank you both.
Thank you.
Next case for argument is Pinnacle Managing versus Slade Industries.
Good afternoon, Your Honors. Edward Weissman, attorney for Appellant Slade Industries Incorporated. This is an appeal from an order which denied Slade's motion for summary judgment, dismissing what we perceive as a baseless and vexatious lawsuit commenced by plaintiff. There are 3 independent bases for the reversal of the order of the court below. The first is the doctrine of voluntary payment, which this court has upheld numerous times, and those cases...
Well, don't they have to, in order for that doctrine to be appropriate here, wouldn't they have to have known at the time that they made the payment the problems that later developed? I mean, there were problems that later developed that they sued for, but they claim that they did not know the extent of those problems.
Your Honor, they had a month to review our invoices, which they asked for because they were terminating the relationship.
Right.
They reviewed them for a month.
But the invoices don't necessarily show all the problems that there are.
No, but they had an opportunity to investigate the invoices.
So here's my question. To the extent that service tickets weren't provided, there wasn't a lot of detail available. Doesn't the information become available when the building dispatch statements are provided pursuant to, during the course of discovery rather, and that's where they find out that there was no performance, there were no technicians sent at different points from 2015 to 2017?
Your Honor, when we gave them the invoices, and this is a 12-year relationship.
Did you service 80 buildings for them?
Yes.
And the dispute relates to 6 of the 80?
Exactly. What they didn't do, and which Your Honors are getting to, is they had available to them an elevator consultant. They didn't consult with their elevator.
But I'm talking about documentation, counsel, with respect to, excuse me, I didn't finish.
Sorry.
So with respect to the building dispatch statements, which we reviewed, that has a lot, they show a lot of gaps. Sometimes there was one that had a, 5-month gap for one building. I saw, it was like a checkerboard, 1 month yes, 1 month no, 1 month yes, where nobody was sent to the building. How would they find that out from an elevator consultant?
Your Honor, they had an opportunity to sit down with us and give us an opportunity to supplement it or to answer their questions. They did nothing but write us a check for $312,000.
How would they know that there was something amiss?
Because they get all of these copies at the time. It wasn't that we handed it to them that day for the first time. But Your Honor, it gets even worse. We leave. We're happy to go. We moved on. 7 months later, there's a phone call from somebody or a couple of somebodies who say, you know, they didn't use proper lubrication in the maintenance of the elevators. That person has no name, no title, no experience, and...
Well, we don't know that. He has no name or title.
He has no name, and they come up with the defense that elevators that are 60 and 80 years old somehow didn't get proper maintenance.
But let's go back to the beginning, which is that if record appears to indicate that the elevators need to be lubricated monthly, yes?
Yes.
Yes. So if the building dispatch statements show that there was no maintenance on a monthly basis, then the lubrication wouldn't have taken place, right?
Yes, but those elevators would not have been 60 to 80 years old if my client did not provide proper maintenance.
Are you conflating issues? Are you conflating issues like apples and oranges?
No, I'm not. I'm not. These elevators should have been upgraded years before as we requested. They never did. They sat down, they gave us a check. 7 months later, this fictitious expert comes in and he tells the bookkeeper, listen, I think they needed more maintenance. We don't have a name, we don't have anything. They needed an affidavit by an expert to support their one disputed issue of fact, which is that there was improper lubrication. This case, under the doctrine of voluntary payment, they wrote a check. If you were to reverse, that doctrine would be preserved. There's also the doctrine of accord and satisfaction, and even under a traditional summary judgment analysis, they have to lay bare their proof. They have to come in with an expert, not the bookkeeper, repeating what some unidentified.
Okay, let's hear what your adversary says, and then you'll have a couple minutes to respond. Thank you very much, Mr. Weiss.
May it please the court, Ira Glauber from Dilworth Paxson, counsel for plaintiff responded. This is the appeal that never should have been perfected.
What are the damages that you're seeking in your breach of contract course
Easy,
of action?
easy. The new elevator company sent us bills and proposals for work that had to be done to fix their work. That's in the record.
Was there any way to have determined that before your new elevator company went
sorry,
in?
is there-
Was there any way that you could have determined some of these problems before you say your new elevator company went
Absolutely
in?
not.
Could you have gone and interviewed people? Could you go and review them with an expert?
Absolutely not, Judge Kaplan. They were the elevator repair and maintenance company for 20 years. They were relied on. We thought that they were doing their job.
So
We
what you're
did not
saying
get
is that,
those
so what you're saying is that what they owe you is that after they left, the new company comes in and presents you with bills for work the new company says represents things that weren't done by the defendant that should have been done. Is that what your case is?
That's part of it, but there's more than that because there's a third one as well, which is the elevator. I'm not an expert. They certify safety for the building department. And they themselves said that there were serious problems with a failure to oil and maintain the elevators. But what
So, you know, in terms of refuting the voluntary payment doctrine, when you look at your complaint, on page 19 of the record, paragraph 9A, you bring your relationship to an end in December of 2017. Your payment, I believe, of $312,000 was made in February. But in paragraph 9A, you're talking about a problem that you had with the defendant in early 2017. So you knew that the work they were doing left much to be desired. And 9B has another case in another building where there's problems. Although I have to say in 9B, you don't put dates on it, but 9A, you do put dates on it, so that it's clear in 9A that the problems preceded your decision to pay.
they were not known at the time. In 2017.
9A says in early 2017.
Yeah, they rebuilt it, but we didn't know of the problem.
So you didn't know it at that time. You say now that you're doing the complaint, now you learned. And
That's absolutely correct.
Well, they were still your elevator company. Slade had to come back to the building to make repairs more than 20 times, but it still could not fix the problem.
That's absolutely correct.
It has to be before December 1st, 2017, when you terminated the relationship.
They were supposed to do monthly work. They were supposed to come back all of the time. But look, we're not an elevator company. We own buildings.
You're telling us, are you not, that you weren't aware of these problems when you decided to make the payment?
That's absolutely correct.
How does that square with paragraph 9A of your complaint?
Perfect, because that is simply one example. There is evidence in the record.
We're talking about only 6 buildings out of the 80.
That's right.
That's 1 out of 6. You list 2 examples in the complaint, but one which is clearly predates the determination to end the relationship.
That simply says that we paid them to do work that we learned about later that they did not do properly. That what we paid them, we found out later than what we paid them, we didn't get what we paid for. The client did not know that when they made the payments. There are factual issues here. We all know what the elements of accord and satisfaction are. There has to be an intent to settle a dispute through payment of a lesser amount. They gave us invoices for $312,000. They were paid in full. There's no release in the agreement. Here's the record. Where's the release? Where's the settlement agreement? Where's the letters and the emails showing that there was a dispute? There is nothing. So clearly out through the window goes the accord and satisfaction defense. There's an issue of fact. The main defense is voluntary payment. We all know that there must be knowledge before you could make,
I think we haven't talked about the main core issue here, and that is under Dillon and its progeny. Did you have a due diligence type obligation before you paid, based on the information you had at the time, to undertake that due diligence at that point before making the payment? Because you had some knowledge, as Justice Friedman was discussing, you had some concerns about their performance, understandable, that you're right. But armed with that knowledge, did you have a due diligence, what I'm calling a due diligence type obligation, to review their performance, see if you had concerns before making the payment?
There is no way that it could have been done. We were their prisoner. They were the only elevator repair and maintenance company that we had. We could not fulfill any due diligence obligation until afterwards. And it's not just that a new company came in and wanted to dump on the old company, because there also was the independent one that certifies safety for the building department. But there are factual issues here. Counsel for Slade was saying, well, these elevators, they were 80 years old. If you have an old car, and if you oil and lubricate the old car, it could last a long time. That was the fundamental dispute here. They wanted Pinnacle to install new elevators so they could make more money that way, and so there was a disagreement. We paid the invoices in full to the penny. So clearly there was no accord and satisfaction, and there has to have been a factual issue about voluntary payment because there was insufficient knowledge, and if you make a payment based on a mistake, that also means that you can't rely on that defense.
Okay, thank you.
In order, if I can have just a minute, in order for
You have 2 minutes.
2 minutes. In order for the doctrine of voluntary payment to take effect or not to be enforced, they have the burden of showing that we engaged in some kind of a fraud or that there was a mistake of fact. They have not set that forth. And with respect to the summary...
Case law that says they have to allege fraud in order to...
They have to demonstrate that there was fraud under the doctrine. And if they can't, they don't even...
Case law requires that.
They don't even...
What cases require that?
The cases that we cite in the brief under voluntary, each one of them cites to it. They have nothing. And it gets worse because when it came time for them to come up with an expert who was going to substantiate their position, 60 or 80-year-old elevators will suddenly become state-of-the-art if you give them a little more lubrication. They had to make up the existence of an expert who I think we understand does not exist. Somebody got on the phone and told them something, and that person did not submit an affidavit with the motion for summary judgment. The court below was reversed a few years ago for not enforcing the voluntary payment rule. It's the same situation again.
Sir, if we gave the voluntary payment doctrine the effect you want us to and apply it as a matter of law here, would we be dissuading future actors from paying promptly and then and dealing with concerns they have that come up shortly after the payment? Would we be dissuading that sort of prompt payment?
Yes, and not only that, but you...
And you're saying that's good, that when someone...
No, I'm not. People should be able to work out their disputes, and when they shake hands and payment is made, it's finished. They move on. What's happening here is they saw it an opportunity to come back and maybe we can get a few dollars back. That's what's going on here.
Okay, thank you. Thank you both very much. We'll certainly take another look at this. And the last case is Kazana?
Kazane, yes.
All right.
Good afternoon. My name is Daniel Notice, and I represent the appellant Heather Kazane. May it please the court. 11 years ago, this court...
Mr. Notice, I have a question. It seems to me what our jurisprudence requires is that, in general, we keep our hands off interim orders unless there are exigent circumstances. Your client is living in a very nice place. She has access to approximately the same amount of monthly money that she did throughout the divorce, but certainly an amount of money that's not going to cause her to be in any emergency. So I'm having trouble understanding what the exigent circumstances are that should require us to interfere with this very thoughtful and lengthy decision, especially because I have a concern that if we tweak the exigent circumstances requirement, then everybody would come to us to challenge interim agreements, interim orders, because by definition, they're always a compromise. So why would we want to do that?
Justice Ginsburg, you got to my two main arguments today. Can I address your answer?
Of course.
Question, I should say. This is not an appeal or a decision from a motion court. I agree, it's a very lengthy decision. But to borrow this court's decision in Kyra, quote, from 2012, the first case that came out really after the guidelines, the motion court did not strictly comply with the requisites of domestic relations law section 236B5A.
Right,
It's
but
illegal.
Kyra didn't change our jurisprudence that we don't interfere with an interim order unless there are exigent circumstances.
But that's an order that's made in compliance with the statute. And this court has said, and Your Honor, Justice Gesmer, Justice Friedman, have been on more recent panels where you either, in Justice Gesmer's case, reverse the maintenance award on a pendente lite basis, because what happened here, very simply, was the first $203,000 of income of Mr. Kazane is subject to this calculation that we all plug into a spreadsheet. Any income above that, obviously here it's a lot more based on just the two KLG affidavits, but even according to what Justice Hoffman determined in this long decision, is not subject to the same 30% and 20%. So what the court did here, it took us, just so this court's aware, 6 months for this pendente lite decision. And what's ironic is if you look at what the court was required to do, this is not...
Most people settle these issues.
Your Honor, I can get to that in a moment, but in terms of the error, it's an issue of legal error here. This is not even an abuse of discretion, or to the court's point about, I was trying to find out the start point. 40 years ago, 50 years ago, thousands of cases in the state. Every department, every appellate division says the same thing. Any perceived inequity of a pendente lite award is resolved at speedy trial, Justice Kapnick. Right. I submit, and I put it in my brief, and I think it's actually, this is, I don't know if the court wants to write on this, but it affects Ms. Kazane, it affects hundreds of litigants in this county.
But
and
that
practitioners, that doesn't
also
exist anymore.
assumes exigent circumstances.
No, it doesn't, Justice
Oh,
Ginsburg.
yes.
Exigent.
Just in our recent decision, like 2 years ago on Lesser, that I was on, I think I was on it, but our decision on Lesser in 2022, we again repeated the exigent circumstances standard.
And I agree, exigent circumstances is the appropriate standard for appellate review pendente lite when the lower court, when the motion court, I should say, follows the statute. Not only that, the second phase of the statute's very clear. The second above the $203,000 income cap, you look at statutory factors A through M, 13 factors, which, by the way, in our motion, you have a 2-volume record on a motion, so clearly it was very, very, very developed. We went through each factor. Justice Hoffman was required in this lengthy decision to go through the factors the court considered, 13 factors, including the catch-all, and say, I looked at the age and health of the parties. I looked at the length of the marriage. This is a 25-year marriage going on year 27. You have 2 grown children. Hard talk still exists. You look at the pre-divorce standard. KLG gave the lower court considerable spending in its analysis. They looked at.
They didn't even have a final report. You had, not from what you presented from KLG was not a final report. It had no supporting documents at all.
KLG relied on documents produced in discovery that both parties had. They looked at hundreds of transactions, 7 accounts. By the way, they looked at it during the 2018-2019 year, because ironically, Mr. Kazane, as of the time the motion was fully submitted, there wasn't even a preliminary conference held at that point. He submitted 3 statements of net worth, each time further reducing his expenses, which, by the way, he admits he did in 2021 during the middle of a
All
pandemic.
right, counsel, I'm going to have to stop you. Let's hear from the other side, and we'll give you a minute or two to respond. Thank you.
Thank you, Your Honor. Joseph DeMarco of the firm Schlissel Ostro Carabatos PLLC for the respondents. May it please the court. Your Honor, Justice Gesmer hit on a very important point here, which is that there have not been any exigent circumstances warranting a modification of this award. Okay, this case started in March of 2021. For approximately 14 months, Mr. Kazani provided his wife with approximately $13,000 a month in voluntary support. It wasn't until 14 months after commencement of this case that we were faced with a quote-unquote emergency application for temporary support. The $13,000 a month that Mr. Kazani was providing was consistent with the status quo that Mrs. Kazani acknowledged in her papers. It was consistent with what her first attorneys requested that he pay when the case first started. That was 2 lawyers prior to Mr. Notice. Now, that voluntary support was adequate, but nevertheless, Ms. Kazani came to court filing an emergency application where she requested $65,000 a month in temporary support.
Understanding that the requested amount was not provided, but rather a much lower amount, was it an abuse of discretion for the judge to say that from that reduced amount, 30% should be paid by the wife for housing costs that the husband previously paid 100% for?
Right, so Your Honor, the support award was $17,000 a month pursuant to the order, which was in excess of what Mr. Kazani had previously been providing for the past 14 months and prior. So to answer your question, it was not an abuse of discretion, okay, nor was it legal error. The statute itself, subsection M of the maintenance statute,
Because when you do the math, it sort of comes out to continuing the same amount that had been provided before.
I apologize, Your Honor, I missed what you first
When you
said.
do the math, does it more or less come out to what had been provided before?
It does, Your Honor, because Mrs. Kazani's 30% contribution of the household bills is approximately $5,000 a month. So when you subtract that from the 17, it's $12,000 a month, which is approximately what he was paying. And now at a time when Mrs. Kazani has refused to hire a housekeeper, so the expenses are actually lower. But subsection M, to answer Justice Gonzalez's question, it specifically authorizes the court to do this. Subsection M says, in determining temporary maintenance, the court shall consider and allocate, where appropriate, the responsibilities of the respective spouses for the family's expenses during the pendency of the proceeding. The court did that. Not only that, this court authorized that in the Warshaw case. In addition, the Third Department has authorized this in Galvin. This is appropriate. Counsel's argument that a court may not allocate expenses when it goes beyond the cap would essentially mean that anytime the court goes beyond the income cap, that payee spouse would never have to contribute towards household expenses, which would be contrary to the statute and the case law. So that argument just doesn't work.
Okay, any other questions? Thank you very much.
Thank you very much. I appreciate it.
I may just to briefly address the 30%. What Justice Hoffman, who I respect immensely, did was basically create a landlord-tenant relationship. As I mentioned earlier, the statute required the statute refers to shall in every single place. And
Are you saying that the maintenance award isn't supposed to cover housing expenses?
not, Your Honor, if you look back at Kyra and the cases that flowed after Kyra, no, in a case like this, you look to the A through M factors, the 13 factors above the income cap, above $203,000. So absolutely not, Your Honor. And in fact, what Justice Hoffman did in the decision was upend the status quo that had been in place for 27 years. Now, with respect to the respondent's claim that was made to Justice Hoffman at the interim relief application and throughout their papers below and on appeal was my client's first attorney. Right after commencement, there was no statement of net worth. There was not a single piece of paper produced in discovery by the moneyed spouse husband. He asked for a sum certain of money. That was never intended to cover any of the pre-divorce marital standard living expenses. Doesn't intend to cover clothing, vacations, every other commutation, going to the hairdresser, everything my client did. She hasn't worked since the date of marriage. She's been completely reliant on this extraordinarily wealthy husband, who, by the way, I want to just raise one other error. The statute specifically provides that where a motion court, like Justice Hoffman, cannot determine the payor's income, and income is defined, again, it's not discretionary, shall be pursuant to the CSSA.
Okay.
Can I wrap up in 10 seconds?
This is 10 seconds.
It's a needs-based award in this case. You read the court's decision, he doesn't even address all the income sources, and he certainly doesn't address my client's needs, despite the fact that she filed the net worth statement and 2 affidavits from KLG. Thank you very much.
We will review all those. And
Have a nice summer. Thank you.
Have a nice evening. Thank you.